It is today.
But you know that. Forward that creates a space.
How about yourself?
Good morning.
You're welcome.
Well, we were feeling a little lonely yesterday, so today I guess we don't have to worry about that.
Don't expect.
So welcome to day 2, which is day 1 of the, well, actually not, it's day 3 of the Flowline rulemaking. And thank you all for your attendance in advance. And we look forward to an interesting day. So shall we start with a roll call of commissioners, please?
Commission Chair Benton.
Here.
Vice Chair Holton. Vice Chair Boygan.
Here.
Commissioner Egger.
Here.
Commissioner Hawkins.
Here.
Commissioner Jolly.
Here.
Commissioner Overture.
Here.
They should have received it.
Commissioner Randall.
Here.
Commissioner Walt.
Here and on time.
Mr. Chair, I have 8 of 9 here.
Thank you. And Commissioner Holton may or may not dial in, but I believe that he will be listening and commenting and not voting because he was not present for the initial rulemaking. And I think that also, Commissioner Walk, that is, we welcome your presence and your insights, although you will not be voting.
That's correct.
Okay. Briefly, I was asked if there's a possibility for some commissioner comments. So any commissioner comments?
Yes, Representative Rankin checked in with me early this morning to see how the mill levy went yesterday, and he was pleased to find out that we'd passed the 4 mills. He informed me, and he wanted me to pass along that there's a bill being drafted. I forget the representatives' names, to address orphan wells. And he suggested that we plan on, he's aware of the gap, the timeline it takes, and he suggests that we ought to be thinking about doing this all over again with the levy increase to support what they're going to do. He didn't tell me how much, but he thought it might even be a lump sum that they're going to recommend to apply towards wells. But anyway, he wanted us to know they're thinking hard about it over there. And we're pleased that we were addressing it as well.
Thank you, Commissioner Jolly. So with that, we'll turn it over to the director and the staff presentation of the, we hope, final proposed rules.
Mr. Chairman, we actually have a preliminary matter we'd like to bring to your attention.
Yes, Mr. Martin.
Your enthusiasm is catching.
Sorry, it's been a long day.
Already. How about I make this brief? That the staff issued a new revised proposed rule on January 26th. It contained some new requirements that we hadn't seen before, and which raised some significant concerns, at least among the industry parties. On February 6th, we filed a motion effectively to supplement the record with the declaration of Mr. John Lesko dealing with optical gas imaging and its feasibility for detecting leaks from below ground pipelines. We're here today to request the commission move to grant that motion to supplement the record. We are unaware of any objections, but obviously any party who does object is free to do so now.
Just a moment, please. All right, thank you, Mr. Davenport, for some guidance. I think the first question would be, has staff had read the memo, and do you have an opinion on it?
Yes, staff has reviewed the motion and the declaration that was filed with that motion. And we do not object.
You do not object?
We do not.
To granting the motion? Okay. I think the next step would be have commissioners had a chance to read what Mr. Lesko has provided. It was in our packet.
Mr. Chairman, we have copies in case anyone hasn't had a chance to look at it.
Are there any other parties to the rulemaking, and specifically parties to the rulemaking, that have an objection to including this memo in the motion? Seeing none, any commissioners have any objection to granting? Seeing none, I think I'll ask Mr. Davenport, but I think what we probably may want to do is actually have a commissioner's vote on granting the motion. But I'll ask Mr. Davenport to provide us a bit of guidance here.
I think a motion and a second and a vote to grant the relief requested in the motion would be a good idea.
Very well. Commissioners, someone like to make a motion that we...
I'll move to grant the motion.
You grant the motion, and so it's to, how would I word that properly?
Mr. Chair, I think, and I would ask for a correction from council if I misstated it, there is a motion dated February 6, 2018. It's titled Industry Parties Motion for Leave to File Expert Declaration of John M. Lesko. in support of comments on final proposed rules, and the request is that you grant that motion. The industry party's motion, and so the motion from the commission would be to grant that particular motion that I've just described.
Okay, so that is the motion that has been made. Is there a second for that?
Second.
Okay, seconded by Commissioner Ager. All in favor, please signify by saying aye. Aye. Opposed, same sign. Motion is granted.
Thank you, Mr. Chairman. If anyone would like to ask questions of Mr. Lesko, he's available today by telephone.
We may.
Great. Thank you, Mr. Chairman.
Thank you. Now, thank you, Mr. Chairman. Matt Lepore, Director of the Oil and Gas Conservation Commission. With me at the table is Mimi Larson, Assistant Attorney General. We want to present the highlights to the changes that staff recommended first on January 26th. All of you have a copy of those proposed revisions. Subsequent to January 6th, on February 9th, staff issued some additional proposed changes. Okay, hold on. Turn it on. Thank you. February 9th, staff issued some additional proposed revisions to the integrity management section, 1104 rules. And today we will introduce you to a couple of additional, I would describe them as wordsmithing or tweaks. I don't really think they're substantive, but there is some clarifying language. So the primary document that we are going to reference is the January 26th draft. I'm working from a red line. I'm going to show you slides with red line or blue line language. We'll try to go through this quickly. There are about 30 slides. It'll get a little bit more complicated when we get to the integrity management section because of the sort of the second revision set that occurred on February 9th. I think it makes sense for you to jump in with questions as I go if you have them on these particular sections. We are going to start with the definitions. You recall from the hearing on January 8th and 9th that there was some question about defining crude oil transfer lines and some way to differentiate those lines from simpler off-location flow lines. Staff's recommendation is that we do that by a volumetric capacity of the storage tank to which those crude oil transfer lines flow or to which they deliver the product. So the recommendation is on the screen of 25,000 barrels. The red language with the modifier of crude oil or condensate was a late comment from industry in their closing statement sort of filings after the January 26th draft. So we think that makes sense. We don't have a strong feeling about it one way or another, but that's going to come up. And if you want to include that language, it's fine with us. Next, there was back and forth about isolation valves. We've cleaned up that language. I don't think there's anything particularly controversial about this, but that is how we have now defined isolation valve. Off-location flow line, we've also made a change to the off-location means of flow line transferring produced fluids from, rather than a well, an oil and gas location. The difference being that on an oil and gas location, I'll say it this way, a flow line could originate from the back end of a separator, for example, on a location instead of just a well. So I think that was the intent of this clarification, that, you know, comes up out of the ground, there's a well, on the same location there's a separator, goes to the separator. From the separator, it then could go off location. So rather than just tie this to a well, this is a little broader definition. 1101A, registration. All of the first paragraph cleanup are date changes, I think, primarily in wordsmithing, trying to be clear about when these things take effect. So for off-location flow lines constructed after May 1, operators must include the following information. So I used green text on the geodatabase part here to signify this was one of the things that I think was sort of most of a hot topic during the January 8th and 9th rulemaking. And this gets to the mapping question. So staff is recommending now, this previously had been for off-location flow lines, simply the identification of the riser where the flow line originated, and then the end point of that flow line. Staff is now recommending that we go ahead and get the geodatabase information for these off-location flow lines for those constructed after May 1, 2018. Commissioner Benton.
Sorry, just a clarification on geodatabase. Are we comfortable that that is appropriately defined in literature so folks know what they have to provide?
I will have to turn to subject matter experts to really appropriately respond to that. So if I can ask Mr. Ellsworth to step to the microphone.
That language is on the advice of our GIS staff, and a follow-up that they're working on is a guidance document that will describe in more detail that I guess you could say that terminology.
Perfect. Thank you. Thank you, Stuart. Commissioner Golly.
So what degree of accuracy or not accuracy, to what degree of precision does that call for? Or are we trying to get, does it show exactly where in the ground the pipe is? And the size?
I'm reticent to use the word accurate from the standpoint of we're trying to make a representation of that on our database. And that's why we're trying to tie in the relationships to 811 because we don't want anyone to go use this mapping to go dig a hole in the ground. So will it be a strong representation of where that line is? Yes. Is it inaccurate that you could go do excavation? That's an incorrect use of this database. Does that sort of it get to where you're going?
Well, I would never want somebody to think, not to use 811. I just would think we should try to collect the most accurate data we can. I mean, how it's to be released is another topic, but
yeah,
maybe this is the industry gold standard. I don't know.
Yes. It will be accurate based on, I think, the characterization you're giving, but keep in mind, we will use the similar format that PHMSA uses, that you can zoom in so close and then at some point it'll get blocked out.
Thank you.
Mr. Chair.
Yes, Commissioner Egger.
So is it basically a file that's collected with a GPS and it's a shape file that they send into COGCC?
Yes.
Yep. And so a lot of the accuracy is dependent on the accuracy of the meter that they're using?
Correct. But most of those are accurate within a meter nowadays, or 3 feet.
Thanks.
Mr. Chair.
Yes, Commissioner Boygan.
Will this geodatabase translate to the interactive map that's on the website?
Yes.
Thank you.
Shall we proceed? Thank you, Stuart. Appreciate it very much. Thanks, Mr. Ellsworth. Don't go too far. Okay. Another topic from the January 8-9 hearing was what degree of sort of due diligence do operators need to do in attempting to describe or provide information to existing flow lines. So this is the language that we recommend. It, I think, is relatively specific in that we expect operators to review their own records and to make inquiry of their predecessor in interest to see if that predecessor, in other words, the person they bought the system from, if they bought it, what records they have, and to review those records in their effort to provide the requested information. Okay, another topic of some discussion, January 8th and 9th, was around the recording of the easements. And so there are two versions of this. This is the January 26th version, and then you can see we made some changes on February 9th. So I'll go back to January 26th. We said that all documents executed after May 1 that grant a right of access or easement to locate an off-location flow line on lands must be recorded by the operator in the office of the county clerk and recorder of the county where the lands are located. That was the January 26th version. Stakeholder comments suggested to us that often the document that contains that right of access or easement also contains a lot of additional information that's tangential to or simply not really related to the actual right of access or easement, and that it is a common practice to record a memorandum of the access or easement rather than the actual document, which again could be a lease or a surface use agreement or something like that. That, as I understand it, is a common practice for recording an easement, for putting the world on notice that there is a right of access or easement. So that this language was modified from the January 26th version to include that idea, that it doesn't have to be the document, the actual document. It can be a memo that references that document. And if the original document contains a legal description or map, that part must be included in the memo.
Mr. Chair,
Yes, Commissioner Boygan.
not sure how much time you want to spend on questions during this initial process.
I think what I'd like to do is if we could sort of think about questions for clarification, for if you're sort of not sure what the wording means or how you want to get, if we could focus on that as we go through this presentation as well as the parties' presentations, and then sort of save the more discussion questions as we get into deliberation. If is that
Okay. So I'll ask a question that could be construed as a question for clarification. And that is, I think I heard you just say that, for example, an oil and gas lease would qualify as such a document. So I'm reading this rule to say that every oil and gas lease that's executed after May 1, 2018 has to be recorded. Parties generally record them anyway, but not always. So is that the intent?
I think that is a clarification question. So, all right. Commissioner, I would characterize the intent as slightly narrower than that. And that is that if that lease grants a right of access or an easement for an off-location flow line or a produced water transfer line, then either the lease needs to be recorded or again, the memo, the memorandum that says we have an easement over these lands for this purpose. See, the lease is the underlying document. And if there's a map or a legal description of where that easement is, that's included in the memorandum. So depending on, I guess I would say the content of the lease, and if the lease gives you that right of access or easement for these types of flow lines, it needs to be recorded.
Mr. Chair, could I just quickly follow
Certainly,
up?
Commissioner.
As you know, Director Lepore, every oil and gas lease has broad language granting rights of ingress and egress and the rights to use the surface and all kinds of ancillary rights in addition to the right to drill for and produce oil and gas. So my question remains, does that kind of generalized language in an oil and gas lease trigger this requirement? Or does there have to be some specific language in a lease that says, in addition to all the rights that this lease grants, or perhaps to be more specific, the lessor grants an easement across the leased lands for flow lines, utility lines, whatever they are. Which, I mean, there is always that kind of general language anyway in oil and gas leases. It's just an example, sort of a rhetorical question, because you have the same issue with surface use agreements and other kinds of documents. So I'm trying to understand what this is actually getting at.
I was hoping to stop at this is a rhetorical question and let it go at that. Again, my answer to that is pretty legalistic, and my answer is if you, the lessee, intend to rely on that document for your right to put these facilities on that surface or subsurface, you should record this document.
Okay, and so the final question, which we could leave for later, is what's the consequence of failing to do this, other than whatever happens under normal recording laws? This is creating a separate rule requirement.
I think we leave that one for later.
Okay.
That's all right. So, and then with the second wording, just to comment, presume we'll clean up the various typos in there at some point.
Dave, the typos are probably in the slide that I created rather than the underlying document.
I think so. Sorry.
We'll try to get that cleaned up.
You don't have to clean up the slide.
We'll check the document.
All right.
Yeah, and I guess I would just say that I invite Commissioner Boygan to follow up with the industry representatives who you will hear from. Yeah. Okay. All right, domestic taps. Another topic of some conversation on the 8th and 9th. We modified this a little bit to say that essentially the operator meets its obligation by providing certain information to the would-be domestic tap owner in writing. So I think the prior language was along the lines of the operator must ensure that, and here we've tried to be a little bit more specific and say, you hand them a piece of paper that says this is what you should do, or you are expected to do, or the state of Colorado believes is in your best interest to do, then they've met the operator's met its obligation. The other significant change here is that we have placed the burden of providing odorant from the get-go and for the life of that domestic tap on the operator. And I promise you will hear some unhappy operators today about that fact. We don't believe we're interfering with contract. We do believe that the state of Colorado has full authority to require this, that there's a regulatory risk that exists, even if you have an existing contract, that the rules and the law will change over time. And if you've been sitting around for 15 years or 20 years or longer with your lease and haven't asked for a domestic tap and you want to ask for it after May 1st, this is how it works. This thing is really touchy. Registration of crude oil and produced water, crude oil transfer lines and produced water transfer systems. Don't think there's anything new here. Minor changes in the registration timing, clearing up the dates that all this becomes effective. We did pick, so there was a question about how much time will the operators have to register existing flow lines. Our staff's original proposal was a year. Industry asked for 2. We split the baby, split the difference, and came up with October 31st, 2019. And we've used the same sort of standard of due diligence here that we've talked about previously. So 1101D is disclosure of confidential Form 44 data to local governments. I know this is all blue. I wouldn't swear that all of this is new language on January 26th, but be that as it may. The main change here is the understanding that the information on the Form 44s, which will include that geodatabase information in some cases, will be provided to local governments. It is being provided to them upon their request. It is also being provided to them with the understanding that it will be used internally by them for their purposes of emergency response and planning. But that is the intent. And as part of that bargain, the local governments agree that they will use their best efforts to keep this information confidential, just as the state will. And that before we provide the information, we will ask local governments to sign a confidentiality agreement that embodies the things I've just said, that this is being provided to you. It is our understanding that it is protected from disclosure under the Colorado Open Records Act request, that the state is taking measures to honor those confidentiality provisions, and that you, the local government receiving this information, will abide by sort of the same rules. So,
Mr. Chair, may I ask a clarifying question?
Sorry, yes, Commissioner Overdorf.
I think you just answered this indirectly, but just to be completely clear, when you say executing a confidentiality agreement, that's a confidentiality agreement that's being provided by the commission and under terms that are defined by the commission rather than by the operator. Is that correct?
that is correct,
Okay.
Commissioner. We anticipate drafting a standard confidentiality agreement if you want the Form 44 information.
Great, thank you.
I think these are relatively minor changes regarding welding. And so in 1102 D2, the changes there came after the January 26th revision at industry's request to accurately reflect the agreement that they had reached with the pipe fitters about which lines are subject to these requirements. So we had crude oil transfer lines, and the feedback was there are other steel lines besides crude oil transfer lines, and this rule should apply, these requirements should apply to all steel lines. So that's the change in the top. And I believe the blue text was inserted simply to capture one of the available standards that could be complied with. And part 4 there is, again, I think just a clarification about non-destructive testing, when it is required and when it is not required. And it's not required for repairs of existing steel off-location flow lines or steel crude oil transfer lines. (1102I) maintenance was discussed during the January 9 hearings. I don't think this is terribly controversial, simply changing the timing of reporting a condition that could adversely affect the safe and proper operation of a flow line from within a reasonable time to as soon as possible. (1103) isolation valves on flow lines and crude oil transfer lines. During the January 9 hearing, industry expressed concern about unintended consequences of fully opening and closing these isolation valves. Staff concluded that those were legitimate and that there were other ways to approach this. And those are captured in this language. So the operators annually must do one of the following: perform a function test or maintain the isolation valve in accordance with its manufacturer's specifications. Obviously, they must repair or replace isolation valves that are fully operable. I made up a word, that are not fully operable. And then finally, on location, manifold piping and process piping was the language that staff had in its January 26th release. Industry thought that peripheral piping, manifold piping, and process piping should all be included there. And after consultation with the engineering manager, to whom I will defer all questions on this subject, we included peripheral piping as well.
Mr. Ellsworth. would you care to, please, how you define peripheral piping?
Well, that is one of our definitions in the flow line. As far as on page 2, that is one of our definitions. And it's an integral item of, and so generally speaking, these are on location piping that is, so we believe it's in the secured area of the operator's control, so it's not off location. And pretty much these are piping directly related to the piece of equipment. So little gas supply valves for operation of that piece of equipment. So that's the reason to be including it, or perspective.
Yeah, thank you. And I apologize for asking you to go through that, but I just wanted to hear how you interpreted that definition. So I appreciate you doing that.
Yeah.
Thank you, Mr. Ellsworth.
Mr. Chair, may I ask a clarification?
Yes, Commissioner Overton.
I'm not familiar with the ins and outs of manufacturer specifications related to isolation valves and what type of maintenance they suggest be performed. But let's assume that there's a manufacturer guide that basically says every 5 years, put some oil on it or something. If the manufacturer suggestions recommend that maintenance occur on a schedule that's different than annually, how will that be treated for purposes of enforcement of this rule?
The when we had the discussion with operators, and they brought in a manufacturer's manual, and then we did engage with that particular manufacturer, and they are the largest supplier of valves within Colorado. So we felt very comfortable with that language from that perspective. And you're sort of correct in your perspective that when you talk about maintenance, that is what they're talking about as far as reviewing and checking the gaskets and sort of oiling or greasing. But most of these are metal on metal type valves, so they tend to be pretty tight, and so that's kind of the perspective. I should say that a very general characterization that the concept of a function test is basically opening and closing the valve. So that's why we were very comfortable with, and that's what the manufacturer's specification, that's the language they used.
Is function test?
Is function test.
Oh.
And function test, if you read it, means opening and closing the valve.
So regardless of the timing that's put forth in the manufacturer's specifications, you need to perform whatever that maintenance is that's identified in those specifications annually.
Yes.
Is that accurate?
Yeah.
Okay, thank you.
That's pretty much what it said.
Thank you.
Thank you, Mr. Ellsworth. Next couple of slides, I think, are we've seen this language before, just carrying that over to another section. These changes pertain to check valves, and essentially the changes here are to include the language of a check valve or other comparable reverse flow prevention mechanism. And if you need details or clarification, you know who to ask. But I think it was just to give some options there. Okay, integrity management. I'm going to preview this for you. So staff met with lots of stakeholders between January 8th and 9th and the release of the January 26th draft. We made changes to the integrity management program, one of which was to require, the language of the rule at the time was optical gas imaging for a number of the flow lines, off-location flow lines, crude oil transfer lines, maybe produced water lines, maybe not, yes. So using essentially that optical gas imaging instrument. the response from the regulated community was twofold. One, singling out optical gas imaging was too narrow, that there are other technologies and instruments and they shouldn't be constrained to that OGI. Our response to that was we didn't intend to restrain you, and we think we tried to define it in a more broad way. But nonetheless, we recognize that concern. Second, the regulated community argued that the technology is, I love the word that one of my colleagues used, nascent and not mature and changing rapidly. And there are different technologies for different applications, that there is no reliable technology for detecting especially small leaks from subsurface lines, and that the requirement, as we wrote it in the rules, would require operators to walk hundreds of miles potentially of flow line with some instrument technology, and that doing so was neither cost effective nor really technically feasible, and that they would spend a lot of time doing nothing but walking those lines. We then convened with the affiliated local government group and Broomfield in particular. I'm sorry if I just put them in the same pod that they weren't otherwise in, but anyway, they were championing this concept of the instrument aided detection, and also of having not just one, but two methodologies of checking for leaks. We had a conversation with them first alone, followed up with a conversation with them and industry at the same time, all of which led to the changes we put out on February 9th. So I will walk through those in two steps here now. I will walk through what we put out on January 26th for all of 1104, and then I will walk through what we put out on February 9th after those stakeholder process that I just described. So in the first two here, for below ground dump lines and above ground on location flow lines, what you mostly see is a negative, that for those kinds of lines, you did not have to use an optical gas imaging instrument because of the way those lines, where they're located and they're above ground and things like that. When we get over here to integrity management for below ground on location flow lines, we added the language, you must conduct an annual AVO inspection using an optical gas imaging instrument in accordance with 1104J. And the language of number 2 there was discussed during the January 8 hearing. If you elect to use smart pigging, the smart pig must have certain capabilities, able to measure flow line wall thickness, measure for flow line defects that could affect integrity, including measurement of metal loss. So that language in number 2 stays. That staff's recommendation is that it stay, and it stays everywhere where smart pigging is one of the options for integrity management. You see the same language here, the AVO with an optical gas imaging instrument in accordance with 1104J, and the options for the integrity management. This is for off-location flow lines and crude oil transfer lines. So the options as of January 26th were annual pressure testing, continuous pressure monitoring, or smart pigging conducted every 3 years, again with a smart pig being required to have certain capabilities. I think this is just the same language for produced water flow lines. So that was what I just walked through, was kind of the state of affairs after January 26th. Again, I've described kind of the response from the regulated community, our engagement with the other stakeholders, after which, with the rules, the proposed revisions on February 9th, we added this language. I'm just going to read the blue part. This is our suggestion, staff suggestion to you, the commission. This comes out of the conversations that I've described with the stakeholders as we sort of process the feedback we were getting. We asked ourselves, what's the right path forward? One of the things that occurred to us was the idea of spending time over the next months or perhaps year or thereabout, paying attention to the technology. So if this is nascent, rapidly evolving technology, let's keep track of it. Let's see what it does over the next several months. Let's do that with interested stakeholders in the room. And it would all be better if it was mandated by the commission in the form of an order. So the proposal from staff is that the commission order the director to impanel a stakeholder group consisting of representatives from industry, local governments, NGOs, and COGCC staff to examine current and developing instrument-based technologies and processes for detecting leaks and spills from flow lines. In 12 months, staff will present to the commission the stakeholder group's results, conclusions, and recommendations, if any, for changes to COGCC's policies or rules. So obviously, after the feedback we received, we thought, I'll say, further study was in order. That said, we also drafted the rules 1104 to include the option to go ahead and use this kind of technology, this instrument-aided technology. So where we had 3 options before, and I'm speaking somewhat generally now, but where there were 3 options for integrity management, we have added a 4th, which is to use the instrument-aided technology. That's assuming the operator makes that election to do so, that they believe that it is technologically feasible, et cetera. But what we took out was the mandate to use that technology in certain circumstances. This is a minor insertion into 1104A. Operators have indicated that they, in fact, often use inert gas to conduct hydrostatic tests, and our engineering staff confirmed that that was legit, and we included that. So here is where we get into the changes now. These are, again, were issued by staff on Friday, February 9th. These were the 2 where we had sort of inserted the negative that you don't have to do an instrument-aided survey. We changed the language to say that you monthly do your AVO inspection and you must survey the entire line. And that applies to below ground dump lines and above ground on location flow lines. Here is the first place in the rules where we have added the language about the opportunity to do the annual instrument monitoring method, IMM Integrity Survey. So that becomes the 4th option, but you can see in the first paragraph, we've stricken the must conduct an annual AVO inspection using an optical gas imaging instrument. And we added the pressure test to the maximum anticipated operating pressure. And so, yes, Mr. Chairman.
So, and this is probably a question for Mr. Ellsworth. 1104J2 is instrument monitoring method where the regulations permit an operator also may conduct a survey using an instrument monitoring method capable of detecting integrity failures, leaks, spills, or releases, signs of a leak, spill, or release. And this is not meant to be a joke, but would a dog fall under that classification?
Only a robotic dog.
So I know of cases and specific cases where the 4-legged critter is much better at detecting their sense of smell is what, 10,000 times or 100,000 times better than a human being. And it's very capable of detecting leaks at a very small amount.
Well, it's difficult to answer that question, but your comment's true. And in fact, that was how the original Florence Canyon City Field in 1862 was originally found. They used dogs to sniff for natural fractures that were leaking gas. So there's a little historical reference. I think we'd have to evaluate that on a case-by-case basis. So
but it would be a possibility.
Well, it's a unique answer and a unique question, so.
Okay.
Yeah, we might look for certification of that dog.
Certainly. Well, it's the same, you know, again, it's no joke because that's what you do for the dogs in the airports.
Correct, yeah.
So I would think that there'd be some level of certification and have to take a test, I suppose. So, all right, thank you.
Mr. Chair,
Yes, Commissioner Overture.
I have a non-dog question, although it is related to pigs. So one thing that one of the conversations that we had at the last meeting when we talked about mapping, and I'm going to try to bring these two things together a little bit, so forgive me. But one of the concerns I heard with some of the mapping proposals was, you know, there are a bunch of flow lines and industry doesn't necessarily know where all of them are. But it seems to me that if you are conducting an AVO inspection, you are walking that line and sniffing and listening and looking, that you must know where that line is. And so I wonder, I also wonder if there's a possibility if you're pigging a line to, again, I don't know all the components, what you can stick on a pig, but if there is a GPS component that you can stick on a pig when you send it through the line, that seems like a way of identifying where that line is. And so I wonder if some of these new requirements that we have for integrity management practices are going to show the location of flow lines, and if we should then not require registration of those flow lines, although they are existing, if we do know the location, should we require operators to register those lines? A multi-part question, I apologize.
I'm still stuck on whether the horse is in or out of the barn, so.
We've moved on, that's old news.
Yeah, that's exactly right. There's a lot of spins off that question, but the first point is to understand that a line that is pickable is a larger line that would more than likely be a known entity, particularly from the standpoint of it's going to have what's called a launching, a place where it comes up out of the ground and you can launch that pig. If you could launch a pig, you could do exactly what you're saying. You could put a GPS on it, and if it was unknown, it could be then known. I believe that sort of a broad comment is if it's large enough to get a pig into it, it's probably in the greater than 6 inches in size, and you would know exactly where that line is. And this would not be one of the ones, when we discuss lines that are unknown, those are older poly lines that are untraceable. Those would tend to be more in the water category, more than likely. And they're probably in the 2 to 3 inch size, which would be an unpickable size scenario.
So then does it make sense to require registration for those piggable lines that we do know the actual location of? Because my understanding is that the way the current proposed rules are drafted is that the registration requirement only applies to lines that are constructed after whatever the half a baby date was in 2019. Is that accurate? Or
I'm going to rephrase that for clarity, is that all lines need to be registered. What you're discussing is the GPS, the geodatabase.
Yes.
The geodatabase, I should have said this when I said it, we're discussing this before. The reason we're using the verbiage geodatabase, it has the shape file that says location, but it also has embedded in that is a description of the material, the fluid, the size of the pipe. That's what a geodatabase would, that's the point of geographic plus data. So that's why we're using that language. And that is a retrospective forward mapping.
So I think, just a comment, we are perhaps drifting a bit from clarification. So
Director Lepore, if you want to add a little bit here, and then let's
I don't
move
know
on.
that we are. I think we're trying to figure out the scope of some of this, which is a factual question.
Which I'll leave that, but I also think that when you think about what the rules require for registration, it's to the best of the knowledge of the operator for any existing flow lines. So if an operator is going to go out and walk a line, either with a gas detection device or something like that, then that is the best of their knowledge, and that's going to fall under that part of the registration. That's
Well, I'd submit that that might be deliberation, Mr. Chair, but
yeah.
I think what we're trying to figure out is the scope of the rule.
Okay.
So show me go back and let me just see what the citation is. Mr. Chairman, if I may, and Commissioner Overturf. So we're looking at 1101A, which is the off-location flow line registration requirements, and 1101A2, big B, for off-location flow lines in existence prior to May 1, 2018. Operators must, to the extent such information is known by the operator, et cetera, provide all of the information set forth for future flow lines, except the geodatabase, but latitude and longitude of the risers. What I think you're suggesting is that we include a provision that would be modified by to the extent known or attainable, perhaps, geodatabase information, if that could be acquired.
That's useful because I did not put that together, that the geodatabase was explicitly excluded from that list. So I will look forward to having a further conversation about this in deliberations.
Right, I think that's great. And again, I mean, so the counterbalance to that is that what we are currently asking for is the latitude and longitude of the risers, which gives you some information about where it starts, where it stops. If your hypothesis were borne out that you could smart pig it, and the smart pig was carrying a GPS device, makes sense to me, but I'm not a technical guy.
Thank you.
Okay.
Thank you. I appreciate the clarification.
All right, so back to the slides, commissioners. I jumped ahead. Well, actually, Commissioner Chairman Benton jumped us ahead to 1104J, and I think it's useful to land on this for a minute because this really is where we spell out this idea of instrument monitoring method, which is CDPHE's language, essentially, or their terminology. So we kind of adopted that. And you can see what we struck on February 9th, the obligation to use optical gas imaging instrument designed for and capable of detecting hydrocarbons. And in its place, we have this instrument monitoring methodology language. So that 1104J gets referenced in many places up above, and I'll go back to those now, but this is now staff's proposed language. So we talked about 1104E and now F, off-location flow lines, crude oil transfer lines, same construction, same idea. There are 4 options now instead of 3. The AVO using optical gas imaging is not mandated. It is an option. This is for off-location below ground produced water flow lines. And I put this up here mainly because there is a typo in what we sent out on February 9th. So A, B, and C all should be ors, there is no and there. So it's still, you have a choice of those 3 methodologies. Okay, so I'm back to 1104J. I skipped a couple of slides, very, very similar language in specific applications. On J, industry has suggested that including the name of the employee who conducted the survey and I forget what else. There was something else they wanted stricken. Doesn't matter. So we think that that's not too burdensome to include the name of the person who conducted the test. So we left it in. So you'll hear from them maybe that they don't want that in there.
Certainly, Commissioner Hager.
I need to go back because I'm having a hard time with the frequency of, or what types of inspections. And I'm a visual person, and this helped me a lot the first time. Am I right, Mr. Ellsworth, that this hasn't changed now terribly, except there's an option for the instrument aided detection method, which will be studied more in the future and potentially become required in this matrix?
Yes, I believe that chart I created at our original meeting, which was before I don't know if the word flip-flops right, but we've kind of bounced a little bit. So I believe what the chart you're showing is where instrument AVO was an option.
Right, but the rest of this still applies.
Yes, ma'am.
Thank you.
Commissioner Ager, I may just draw your attention though, potentially to the dump lines. In the December 22nd proposal, dump lines had the option for monthly AVO. Now it is an and monthly AVO.
Thank you.
I don't even know what else is in here. Okay, I think we're getting close to the last slide that we wanted to present. This slide highlights the changes made to Rule 602. These changes were, again, part of the January 26th change. And the changes here have to do with the reportable injury, and it references OSHA. And then Part 3, any accident or natural event that results in injury to a member of the public that requires medical treatment. I think that's additional language. I didn't bother to make a slide, but we did strike the word analysis after root cause. That seemed to cause a great deal of consternation. So you just have to tell us the root cause, however you got there. I think that's all that staff wanted to present. I know you will hear from other stakeholders and they will likely give rise to further questions, but happy to attempt to answer any additional questions at this time.
Commissioners, any other questions for staff at this time? Thank you very much.
I'm sorry.
Sorry, Commissioner Overturf. I overlooked you. I apologize.
I have just one that I'm not sure I think this is a change from the December 22nd rules to the January 26th rules, that in Rule 711, there was an exemption of for those individuals who processed 80 barrels of water per day, and that in the January 26th, that was changed to 700. I was wondering if you could speak to that change.
Thank you, Commissioner. Mr. Ellsworth would be happy to speak to that.
Yeah, what I did is I took a look at some of the basins in Colorado and sort of calculated the amount of produced water by operator. And I took a look at the lower water producing basins and fields, and came up with sort of an average by operator. The previous 80 was more based on when I calculated that was based on a per well basis. So when we're talking about these transfer systems and the discussions we had with operators, I looked at it from an operator's gross volume of production to try to get at a water production network.
And do you think that the $5,000 is adequate assurance for such a larger amount?
Well, the idea of that is that's more of the cost of a cleanup for that situation. So this is what I call an environmental bond, meaning if you have a produced water spill, or it's the cost of that cleanup. So that's more where this is going towards. We're not assuring the integrity of the pipe. We're responding to an individual spill and cleanup.
Right, but there could be a bigger spill if you're talking about an operator that's processing this larger amount of water. Is there a reason to think that the spill would be, there's the potential for larger spills? I guess that's where my question about the adequacy of the $5,000 comes in.
Well, these are small systems and small gross volumes. So, and the idea I would like to embed in this is all our other integrity program that hopefully we're getting people to early identify issues and get them cleaned up. So.
Okay, thank you.
Director Lepore. Thank you, Mr. Chairman. If I may, while I have the microphone, I do again want to take the opportunity to thank my staff who have worked tirelessly on this. Just a tremendous amount of commitment to really getting this right as best as can be done. And I want to acknowledge the stakeholders too. I think that this has been rigorous, and stakeholders have engaged in really good faith and brought forward proposals that where they feel that what we've asked for doesn't make sense for one reason or another, they have come forward with, thoughtful and intelligent alternatives. From the local government community in particular, I've never seen a higher level of engagement and, again, very, very constructive sort of proposals for us to consider. So the nature of this beast is that not everybody will be happy. We often joke that if everybody's a little bit unhappy, we've hit it just right. With the January 26 rules, I knew we had pushed at least as far as we needed to go, and maybe it needs to get pulled back a little bit here and there. But I think that was important for us to kind of get to that spot. And I think that if you concur with us about the idea of the stakeholder process going forward to look carefully at that technology, that emerging technology for instrument-aided detection, that would be a nice way to keep this dialogue alive and moving forward. So thank you.
Thank you, Brian. And the last comment is very valuable because it does essentially put us in the position of being able to make changes as the technology develops. And that's much appreciated. And again, I think on behalf of the commission, although we don't see it, it's pretty obvious that there was a lot of time and effort put into this on staff and all the stakeholders, including the local government. So as a commission, we thank you very much for that extraordinary effort to get this to where it is today. With that, I believe our next item is party responses. And Ms. Prine, I understand there may be some changes there. So I'm wondering if you would like to go over those.
Yes, Mr. Chair, we've had some parties who have given their time to other parties. So the order will remain the same, but some of the parties will not be appearing in front of you. I'm happy to walk through the whole list with you if you'd like, or party by party as they come up, whatever's your preference.
I would, perhaps if it pleases the commissioners, we would do what would amount to, say, 30 minutes worth and then a break. So we do what sort of, it's consolidated the first 30 minutes worth of presentations. And then when we come back from the break, we'll go on to the next step.
Okay, so Adams County is first with 10 minutes, and then affiliated local governments now has 20 minutes. They've picked up 10 from the city of Fort Collins.
Thank you.
Commissioners, Jeff Robbins on behalf of Adams County, and Christine Dougherty will be presenting our closing statement.
Good morning, Commissioners, Director Lepore. On behalf of Adams County, I'd like to thank the Commissioners, the Director, and the COGCC staff for the extensive time and effort involved in this rulemaking. These rules are critical for the safety of Adams County residents as well as the oil and gas industry workers who are also members of our local communities. With respect to the Commissioner's time, I will not review every rule Adams County supports. However, I would like to specifically highlight the county support for Rule 1102, subsection N, which requires operators to register Tier 1 members of Utility Notification Center of Colorado, while also including language requiring the submittal of GIS data for mapping under Rule 1101. While examining Rule 1101, specifically subsection 1101A4, the county determined the current language does not meet the intention of our request for a comprehensive map. As proposed, a map only displaying infrastructure installed after a set date does not provide peace of mind with respect to safety in the county of our residents or whom we have spoken with extensively on this matter. If infrastructure, whether new or old, is to be utilized, the location should be known and documented for safety purposes. In consideration of 1105, abandonment, we ask the Commission respect local government land use authority and allow us the right to determine appropriate abandonment processes from the options provided by the Commission. Furthermore, we would request that notice of abandonment be provided a minimum of 30 days in advance of the scheduled abandonment. This would allow jurisdictions to determine and communicate the preferred abandonment procedure with the operator. In addition, the local jurisdictions with inspectors may opt to have their inspectors present during the abandonment process. This minor change would have significant benefits to ensure all rules are adhered to and provide accurate information to our residents. In closing, I would like to stress that Adams County is aware that this rulemaking is not without impact to industry, and we do not make these requests lightly. Considering the safety of our residents, first responders, and trade workers who may encounter unmapped subsurface infrastructure, we cannot decide to do nothing. Adams County is proud of our ability to work with the oil and gas industry, finding balanced approaches to mineral development, but also recognize that we will only be successful by working together. Thank you.
Thank you. Any commissioners, any questions? All right, thank you very much.
Point of order. The city and county of Broomfield desires to go next as opposed to the affiliated local governments, and we don't have any problem with that. We don't know if that's something that you would allow.
Ms. Bryan, how much time does city and county of Broomfield have?
They also have 20 minutes. They picked up 10 from the Fitzgerald-Lackland party.
I believe that would be fine.
Thank you.
Thank you, commissioners. Actually have a witness who is only available until 11, so that's why we wanted to move up the time. So
No
if he could call in now, that would be great. I'm just going to let him know. Okay, so while he's doing that, well, first, I just wanted to echo what Director Lepore said, which is we really appreciate all the staff's effort and all of the stakeholders' efforts in this process. I think the rules that are before you today represent a tremendous improvement on the current rules and also a tremendous improvement on the initial drafts. So we are very grateful for all of the time and effort that you, the commission, has put in, and all of staff and the stakeholders. We have also worked hard to streamline our proposal, and we've removed some of the initial proposals because of conversations that we've had with the staff. And so specifically the financial assurance proposal that we initially put before you, we are now going to work with staff and other stakeholders going forward to look at potential revisions to the financial assurance provisions in the rules. That being said, we do think that there are some additional improvements that are still necessary with respect to the rules. And the two areas in which we seek additional improvements are with respect to the integrity management provisions and with respect to notifications. We are very supportive of the additional option that is now in the rules for operators to use an alternative instrument monitoring method. I would just note, Chairman Benton, that when I read instrument monitoring, I don't necessarily think of a dog, as in my mind, a dog is not an instrument, but certainly that's up to staff to determine if that would be an option. But certainly what we have put forth and what CPC has agreed and put forth is there are a number of technologies other than infrared cameras that operators can use to detect methane leaks. So there are lasers, there's LiDAR, there are a number of mobile mounted options and technology providers that mount lasers and other types of technologies on planes. Some are emerging technologies, mount them on drones. And there are some operators that will walk their lines with a handheld device to identify leaks. So we think it's important and it is very fitting that the rules allow this as an option for operators to detect methane leaks, both from above ground lines and from buried lines. So we're very supportive of that new change in the rules. That being said, we still continue to believe that the best practice is for operators to utilize more than one form of testing. So currently operators only have to do one of the 4 options that is listed. The reason we believe they should do more than one is because each of the testing technologies or approaches allowed in the rules will detect a different type of integrity anomaly. So for example, continuous pressure monitors do not detect small leaks or corrosion. They will detect a large leak or a rupture. Pressure monitoring, on the other hand, will detect a small pinhole leak. That might be Mark. Mark, is that you?
Yes, that's me.
Great, thank you so much. In just a minute, I'll ask you to talk about the Methane Ranger program.
Okay.
And smart pigging will detect internal and external corrosion before there's 100% wall loss, but it, again, is just, it's a corrosion detection method. So we think a prudent operator would combine and choose which 2 or potentially even 3 of these options would be best in order to both detect small leaks as well as large ruptures, as well as corrosion that occurs before a leak actually occurs. By way of example, Broomfield just entered into an operator agreement with Extraction. Extraction has agreed pursuant to that agreement to conduct smart pigging every 5 years, annual pressure testing, and also to fly over their lines twice a year, looking for either leaks or threats to their pipelines, such as incidents that could result in excavation damage. So now that I have Mark available on the phone, I wanted Mark to discuss the Southern Utes experience over the past year utilizing a mobile mounted laser that is manufactured by a local Fort Collins company. So it's a local business, and his experience in utilizing that technology to identify methane leaks from the coal bed methane operations on the Southern Utes land. Mark, would you provide, could you introduce yourself to the commissioners and then briefly discuss your experience using the Methane Ranger technology?
Pardon me, I think. Over.
Sure.
Oh,
I'm sorry.
hang on a second, Mark.
We probably,
Okay.
I think this is.
Are you ready?
No.
No, not quite yet. Apologize.
Not quite yet.
Mr. Davenport.
So it strikes me that it sounds like, and I don't know his last name, but this gentleman's going to be testifying in regard to actual facts as opposed to providing his opinion or other things. And so it may be necessary to swear him in and also make him available for cross-examination from any parties who may want to ask him questions. I'm not aware that this information's been provided before. What is his last name?
It's Mark Hudson. I did submit that he would be an expert and submitted his bio as well.
Okay.
So that has been provided to the parties and the commissioners, but his name is Mark Hudson, Hutson. He's the Environmental Programs Division Head for the Southern Ute Tribe, and he has worked for the tribe since 2013, assisting the tribe to implement delegation of their Title V permitting and enforcement program under the Clean Air Act. And in addition, prior to that, he worked for the Texas Commission on Environmental Quality, where among other things, he served as the team lead on the leak detection and repair program.
Okay. I think we'd like to swear him in, and then, or with the commission's approval, we'd swear him in. And then also, if any parties would like to ask him questions, I think that would be appropriate as well. Again, with commission's approval of that procedure.
Hey, commissioners, any concerns?
May I just ask our counsel, my recollection was that, well, what's the status of the record?
The record, I believe, is still open, but I'll defer to Mr. Davenport.
The status of the record is it is still open, yes.
But my understanding from the pre-hearing order was that the presentations today were intended to be limited to closing statements, correct?
I think that's correct as well. Ms. Prine, is that your understanding as well?
The pre-hearing order asked for comments based on the newest updates to the rules and their closing statements.
So I guess, well, I won't say what my thought is. I'll let other people ask questions, but.
I had the
Same,
I echo that.
Commissioner Boygan. So is it a concern that, sort of, as a layman, and I appreciate any input the two of you may have, to me, this is sort of, in a broad interpretation, fits within that closing statement, because they're saying we think that there should be some other options and instrumentation, and here is an example of something that works. And so, but I'll defer to what the two of you think as far as from, do you consider this part of a closing statement or something new introduced? And I think Commissioner Randall, you may have something here also.
Sure. I mean, I think we're in a quasi-judicial setting. I think the rules of procedure are within our control. I think we've already accepted witness testimony from another party. I personally don't object to brief testimony here. We've invited responses to the staff's updated proposed rules, and I wouldn't mind hearing it. I do think it's appropriate to allow other parties to respond to that if they'd like, but I don't think it needs to be really disruptive. That's just my opinion.
Commissioner Overturf?
Yeah, I think to the extent this is a response to something new that was proposed in the latest version of the rules, I think that it does sound like that is consistent with the final pre-hearing order. And I do recognize, over my trepidation, we did also approve the motion to have the additional testimony from the industry parties. So long as it's targeted towards a response, I think it's
specifically targeted to the new rules, which allow for a range of instrument monitoring methods to detect leaks. So this is one example of an instrument monitoring method that is available and in use to detect leaks.
Okay, thank you.
Mr. Boygan, any?
I would just, I'm fine with that resolution, but I would suggest that industry parties, you may ask for them to be heard on this question, whether it's appropriate or not, first of all. And second, I think they also ought to be accorded the same opportunity, and maybe they're already planning to have their own witnesses to provide similar comments. So I just want to be clear on the procedure here. That's all.
I think
it needs to be even-handed.
Yeah. I think it was pretty clarified by Commissioner Overturf, says that this is related to a response to a change in how the rules are read. And I think as long as we keep that in mind as we go forward, that anything that's a response to proposed changes in the rules that have come up either January 26th or what's the other date, February 6th? February 9th, then I think we're okay. So commissioners, if you're all right with this, it sounds like you are, we'll allow it, but I do believe we need to swear this individual in.
Yes, we can't confirm if you're standing or not, but would you please state your name and swear that you will tell the truth here today?
Mark, are you still on the line?
Yes.
Great. Did you hear that question?
Well, it's hard to hear everything. There's a bad echo in there, so repeat.
Sir, would you please state your name and swear that you will tell the truth in your testimony today?
My name is Mark Hudson, and I'm with the Southern Ute Indian Tribe on the Methane Ranger.
And will you please swear that you will tell the truth here today?
Yes, I do.
Okay, thank you.
Great. Thank you, Mark. I just thought it would be helpful for the commissioners to hear your experience utilizing the Methane Ranger technology, in particular, the mobile mounted laser device that you've been using to identify methane leaks from pipelines over the past year.
Yes, I'll briefly describe the program. We started about last year. I purchased a piece of equipment called tuned diode laser from Red Hen Systems in Fort Collins, Colorado. Basically in response to some studies that were done by NOAA and NASA in 2015 for methane in the San Juan Basin. Started this program last year. It's a mobile mounted, it's on a vehicle. And the purpose of the study was to basically try to find alternatives or more expeditious ways to identify methane leaks within the Southern Ute Indian Reservation. So this system allows the capability to drive in some of the remote areas. It's designed to pick up down to 1 part per million methane, and it actually shows the methane signals on basically like a Google map. So we've been doing this program since last year. We were pretty successful in identifying leaks from not only well pads, but also the side issue of this system was being able to detect leaks that normally wouldn't be found in flow lines. So last year we detected about 8 or 10 leaks, of which we notified the operator. We have no regulatory driver for this system. It's totally voluntary.
Great, thank you. And can you clarify, Mark, whether or not you were able to detect leaks from buried pipelines as well as above ground pipelines?
Certainly we didn't, not any above ground. The ones that we did detect were primarily from the well pads over to, gathering systems, either a compressor station or a trunk. So we were able to actually physically pick up a signal as we were driving to and from some of the wells and actually along the highway. And we're actually able to pick up a signal of which then we followed up with the FLIR camera. Once you pick a signal, it helps you narrow this down to a specific area. And then from there, you're able to fine tune into where the leak is.
Great. And just for clarification, you are talking about detecting leaks from pipelines in between the well site and the compressor station?
Say again, I'm sorry.
It sounded like what you were describing was identifying leaks from pipelines that were in between a well site and a compressor station. Is that correct?
That is correct.
Thank you.
That is correct.
Thank you.
Those types of leaks typically don't get picked up by a new source performance standard, Quad OA, or the BLM onshore leak detection and repair requirements.
Great. Thank you so much. Commissioners, do you have any questions for Mr. Hudson?
Questions, commissioners? I have one brief one. I think what I heard, and I'm asking for some clarification, is that this will essentially detect a presence of methane in the parts per million range, and it can be done for buried lines and while you're driving down the highway at 60 miles an hour. So I'm asking if that's the correct interpretation of the technology.
Yes, that was I assume that was directed to me, correct?
Yes, sir.
Yes, this system actually picks up the signal. It plots it every about half a second on a map that you can actually see, like a Google map. And then the intensity of the signal is displayed, kind of like a graph. But yes, we actually detected one of the leaks that we found was along the highway. And the way we were able to find that leak was after a couple of days driving back and forth, we realized there was an anomaly of a signal along that same stretch. And, we were actually driving the speed limit, like 50. So after a couple of days, we realized where this area was and took a closer look, and it was a leak in a flow line.
So, and I missed out, and it said it's about 100 feet away, sort of. After your experience, what is that potential detection limit? Is it plus or minus 100 feet?
Well, that all depends on wind direction too. That's the key to this, is that, you know, the wind direction has to be prevailing across the road that you're going on. So it may not always be blowing the same direction, but the leak that we detected from the highway was about 100 feet. You know, you can't say that it's an exact distance that you're going to pick up a signal.
Okay. Commissioner Hager?
So I just have a comment and then a question. I don't think we're here today to try to determine if this technology works or if it's something that we should apply. And so my question is this testimony being given to suggest that we don't need a stakeholders group, that there is technology available now to allow oil and gas operators to monitor their flow lines and pick up small leaks, large leaks, methane, above ground, below ground pipes?
So
can you just clarify that?
Yes, sure. So the purpose of this, so the staff's current draft allows operators to use an instrument monitoring method as one of the options. And that's for both buried lines and above ground lines. So this testimony was provided in order to demonstrate that there is one option. There are many other options as well, as we've identified in our filings, of other technologies that are available to detect methane leaks. So this is in support of the current draft and allowing that option. In addition, however, we absolutely support the stakeholder process for two reasons. One, there's a number of emerging methane detection technologies that are being developed, and we think it would be very helpful to further identify additional technologies that operators could use to see if they're appropriate to detect methane leaks. But in addition, there's also a number of technologies that are being developed or researched to identify liquid leaks. PHMSA, for example, as well as the state of Colorado, is participating in some of these research projects. And we understand that stakeholder process will be broad enough to look at both liquid detection methods as well as gas detection methods.
Right. So the testimony is in support of the rule.
That's correct. That is correct.
Commissioner Randall.
Thank you. Thank you, Mr. Chair, and I appreciate the clarification there. I was sort of wondering the same thing. In as much as this is an emerging and sort of nascent technology, can you or could Mr. Hudson give an estimate of the cost of the technology? Because I assume that it would be one of those things considered as part of the stakeholder group.
Yes, of course. Mark, can you tell the commissioners the cost of the Red Hen technology?
Sure. Yeah. The whole system, the laser and the computer and the software was about $80,000.
Great. Thank you.
Not including the vehicle.
Certainly.
Thank you.
Great.
Thank you, ma'am. I think, and no other questions. Thank you very much for your presentation. Oh, wait,
Chair.
I spoke too soon. Commissioner Boygan.
No, I just want to make sure that other parties have the opportunity to cross-examine the witness.
Good point. Good point. Any other parties have questions for the witness? Yes, sir.
Jim Walker, Petron Development Company.
You probably need to come to a microphone, sir. And it looks like, okay, go ahead.
Thank you for the opportunity to ask. I am just curious, the setup costs and then the ongoing maintenance and procedural costs, the total cost of running those types of systems. So what is that running you, and how many wells are you looking at, or how many miles of pipe?
That, Mr. Hudson, did you hear that question? That was directed for you.
I heard a boot.
He hung up on me.
Did he?
You probably need to get him back.
I'll get him back on the phone. Sorry about that.
This happened to me a lot in high school.
That's what you get for sitting in the back of the room.
I did wonder, Ms. Pine, are we out of time or do we still have a few minutes?
You have 6 minutes remaining.
Okay, perfect, because there was one other issue I wanted to address, but
Is it something, can you do it now while he's,
I absolutely can.
okay.
Oh, he's
Oh, there he
back.
is.
Mark, is that you?
Probably. I thought I was done.
We just have one more question for you. Or
Sure.
maybe more than
There
one,
may
but
be more
a few
than
more.
one. No.
My name is Jimmy Walker with Petron Development Company here in Colorado, and I'm a small operator. I'm curious of what, on this instrumentation and system that you've set up, what, 4 parts, what is the initial costs of setting the system up? What are the ongoing costs? What are the number of wells that each unit covers and or the miles of line that it covers?
Sure, I can try to answer that question. So the initial cost of the equipment was, as I stated earlier, about $80,000. That doesn't include our vehicle that we have. The ongoing cost is obviously you have to have one person to run this instrument or equipment, drive the vehicle, and gather the data. Really, probably realistically, 2. Miles of flow line. I can't really answer that because the goal of what we are doing or here is not necessarily for the flow lines as much as it is addressing emissions from well pads. It just happens that, one of the side benefits of what we were doing is detecting flow line leaks as well. So, I don't know if I can answer the flow miles of flow line. I do know that one of the reasons why our program is looking at this is, we're in the Southwest Colorado and there's lots of backcountry where some of these well pads are located, and the logistics of it is difficult. So we were looking for a sort of an expeditious way to cover a lot of ground and a lot of wells fast, which I believe, we're only in our last year was our first phase. You've got to learn the anomalies and how the equipment works. So we were able to basically survey about 500 wells last year over a period of about 2 or 3 months. So I don't know, does that answer your question?
Yes, it does. May I ask one?
Before we go any further, I'm sorry
Right.
to interrupt.
Yeah,
but I
Mr.
do need
Davenport.
to make a procedural point. I believe under the rules and the most appropriate thing to do here is while a party may ask questions, that time, including the answer, will count against your time for your presentation.
Then I'm done.
So, just to make that point of clarification.
After now.
Well,
Retroactive
I'll leave that up to the commission, but that seems fair.
Thank you.
Thank you, Mr. Walker. Mr. Martin? And I think you heard what Mr. Davenport said, so
I intend to be exceedingly brief, Mr. Chairman.
thank you.
Mark, this is Jim Martin. We spoke, I want to think Friday, but I'm not entirely sure. We spoke recently,
Yes.
right? Just a couple of questions for you. Excuse me. So I understand you're doing this basically a pilot project, and you're looking, among other things, at wells and starting to look at pipelines as well. Is that right?
Yes, really not necessarily intending for the pipelines as much as the pads, but I want to reiterate that it's kind of a side pipe that we realize the side benefit.
Right. And when you're out there and you're detecting, as you call them, signals, ambient levels of methane, you have to follow up with some other instrument such as a fluorocamera or a sniffer, method 21, to actually discover the site of the leak. Is that right?
Yes, you are correct. The red hen system that we use is not intended to be operated or used by itself. You have to have the FLIR. Once you survey and scan, then you're able to pin down and find the leak.
Great. And at the moment, your work has been limited to gas lines. Is that right?
Say again?
You've been limited to gas lines, natural gas lines?
Yes, all methane.
Okay.
That's correct.
And were the flow lines where you're detecting leaks, were those flow lines pressure tested?
I do not know that.
Okay. Other than that,
we actually, when we found the leak and pinpoint the leak, there's no regulatory driver here, so we would call the operator, and they seemed pretty anxious or agreeable, and the leaks were repaired.
great. Thank you, Mr. Hudson. Mr. Chairman, with that, industry also strongly supports the stakeholder process, but we want to emphasize that these technologies it's a great word, nascent and developing rapidly. Thank you. Thank you, Mark.
That seems
okay. Am I done?
I'm not sure yet, Mark. You may want to stay on the line, so we'll find out. But nascent certainly seems to be the word of the day. So,
all right.
Or dogs, yeah. Okay, Ms. Prine, how much time do they have left?
Broomfield has 6 minutes left.
All right.
Thank you. Can we let Mark go?
Okay, if any other questions for Mark? Okay, Mr. Hudson, thank you. This time you're free to go.
Okay. Thank you. Bye.
Great. Well, I did just want to mention, so in addition to what Mark just testified about, we put in our closing statement, operators in Colorado have been using helicopter-mounted lasers and IR cameras to inspect for methane leaks. And PHMSA has had requirements on the books for a number of years that have required operators of gathering lines located in populated areas as well as distribution lines to utilize leak detector equipment. There is a suite of technologies available to identify gas leaks, including something very old such as PID devices, as well as lasers, as well as LiDAR. So I would just say that not all of the technology is nascent. But now I'll move on to our other item where we're still seeking some improvements, and that is with respect to notifications of grade 1 gas leaks and reportable safety events to local governments. The rules require that the operators report such events to the director. However, there's no notification requirement to local governments. This stands in contrast to the notification requirement for spills and releases under Rule 906. We do not see a reason for differentiating between a grade 1 gas leak, for example, or an uncontrolled release of pressure, and a spill from a storage tank or a pond. So quite honestly, we believe there's a reason for local governments to know what is going on at the facilities within their jurisdiction. We at Broomfield and other local governments that I've talked to have received complaints from concerned citizens related to loud noises, uncontrolled releases of pressure, maintenance events, things that involve either disturbances or potentially threaten public health and safety. And in many instances, the local government has been unable to provide an answer to that concerned citizen as to what is happening in their backyard or in their open space. So all we ask is that operators report grade 1 gas leaks and reportable safety events to local governments at the same time that they report those events to local governments, to the commission, sorry, to the director.
Mr. Boygan.
Thank you, Mr. Chair. I'm just curious, is there an analogous situation with other industries, other activities within local governments that have similar reporting requirements where there's both a state agency or maybe even a federal agency that's regulating the activity and a parallel reporting requirement to the local government? Can you talk about that?
I don't, off the top of my head, have an answer for you. Possibly, maybe someone from Boulder County might know that. As I mentioned, I do know that the COGCC rules do require the reporting of spills and releases to local governments. So that's the one example that I can provide you.
Thanks.
All right. Go ahead, Commissioner Egger.
This is actually for staff or director. Can you tell me how spills and releases are reported to local governments, do they get notified with Form 19s?
Commissioner Ager, I probably can't quote the rule to you off the top of my head, but I do know that spills and releases under section 902 are required to be reported to surface owner and local government. And again, the timing escapes me, but promptly.
Mm-hmm. And that's reported by the operator or by staff?
It was by the operator.
By the operator. Is there a reason why grade 1 gas leaks aren't being required?
I knew that's where this was going. I'm going to ask Stuart if he can help me. Then you can say that. Anything?
Right now, the way we were tackling that is that it's the Form 44, and we were going to put that on our dashboard so that it was available for anyone to review, and that's how we were going to manage it at this time.
Okay, thank you.
Thank you, Commissioner. And perhaps this is something we may want to bring up when we get into the discussion, further discussion as well. So yes, Director.
Mr. Chairman, I will say that my recollection of the conversation probably started with the premise that a grade 1 gas leak most likely would be reported to emergency responders within the local jurisdiction. And I realize that may not always be the case, but I think that probably was where we started down the path of assumption that local governments would probably know regardless, but.
And if I could just say that the definition of a grade 1 gas leak includes a probable threat to public health. And so in those instances, I don't always think that there will be an immediate call to 911. And the same is true for example, an uncontrolled release of pressure pursuant to the 600 rule reportable safety events. I do believe there are some, as well as an accidental fire, there are some instances where there may be a safety or health threat at a facility that does not necessitate a call to 911, or at least does not immediately necessitate a call to 911. However, again, local residents or passerbys may be quite concerned, and their safety or their health may in fact be in jeopardy.
Anyone else? Any other commissioners? Questions? All right. Thank you very much.
Thank you very much.
All right, I think we will take a approximate 10-minute recess and then reconvene and continue on with presentations.
Wasn't this
All right, so who's next? Maybe the next three plus or minus.
Okay, Mr.
And
Chair,
time.
next is affiliated local governments with 20 minutes, followed by Northwest Colorado Council of Governments for 10 minutes, Weld County for 10 minutes. In total, you have 120 minutes remaining of party presentations. That's not including lunch or any breaks. So just to make sure everybody's on track with our time.
All right, thank you very much. So again, certainly all of us can work hard to keep our questions to clarification, and then we'll have more time when we get into the discussion and deliberation. So affiliated local governments.
Thank you, Chair. Jeff Robbins on behalf of the City of Lafayette. The affiliated local governments are also the City of Longmont and Boulder County, and we will not take all of our 20 minutes. And Ms. Sanchez is going to start.
Good morning, Commissioners. Kim Sanchez, Chief Planner with Boulder County. Commissioners, we also want to thank you and staff for the time put into this rulemaking so far, particularly for the time that staff and Director Lepore have taken pursuant to your direction at the last hearing to meet with us to better understand our position. We likewise greatly appreciate the collaboration that has taken place between the local governments to divide and conquer to speak to discrete issues in front of you during these proceedings. We do think that the proposed Flowline rules are better than they were, and there were some good additions made. However, I think the questions that are nagging us at the close of this all and why we got involved in the first place is, are they good enough, and do they prevent another Firestone from happening? In our closing, we'd like to make 5 points and ask for your consideration as you deliberate what should be adopted in a final set of rules. First, as we've advocated for at the last hearing, and again yesterday at the mill levy rulemaking, we would still like to see the COGCC host a comprehensive database and mapping system of flow lines associated with oil and gas facilities. 811 serves a purpose, but it is not an adequate substitute for a comprehensive database containing this information. We appreciate that you invited a representative from 811 to come to the hearing in January, but as was pretty glaringly revealed that morning, 811 does not maintain a full index of pipeline locations or mapping and cannot provide actual data. 811 is a service that is provided at the time of excavation, but is not used for planning purposes. In fact, they spoke to engineering requests for engineering requests, and operators' responses is voluntary. For engineering requests, which are the planning types of requests, 811's only obligation is to notify the operators or owner of utilities or lines in the area, but those operators may or may not respond to the request to locate, and there is not a requirement for them to provide any information in those situations. 811 also cannot provide pipeline locates for a broad area as is necessary for effective land use planning and emergency planning purposes, as we discussed in our testimony. So while we appreciate the requirement to provide geospatial data for some of the lines, that is, those lines that were constructed May 1st, 2008 or after, and I guess I will note that I think you need to make a slight modification to the rules to have it be May 1st or after, and then prior to May 1st, because right now May 1st is sort of left out of the equation. In any case, while we appreciate the requirement to provide geospatial data for some of the lines, and that information may be shared with local governments who want it, confidentiality being another issue which Jeff will address. Our second point is that geospatial data for all lines should be provided irrespective of when they came into existence. Operators should be required to provide geospatial data on existing off-location flow lines as well, not just those constructed after May 1st, 2018. New data is a start, but what you're requiring of operators through this rule only produces half a map or less. Industry not knowing where the lines are is both the problem and the point of this request. There is no reason that all Flowline data installed in the past and in the future should not be supplied by operators. Industry installed or acquired the flow lines. Industry is responsible for them. They should know accurately where they are and be required to provide that data. Are existing lines any less safe than newly installed lines? If no, they should be held to the same standard and requirements. I'll also note that research conducted since our closing statement was provided led us to technologies that map the location of lines as well as identify leaks. So this can be done. Two companies that you can find through a quick web search are Lazen.com and www.linewiseaerial.com. It's a bit mind-boggling that we wouldn't be getting the more accurate geospatial data for what initiated this rulemaking in the first place, existing lines that are underground. We're asking that you make 2AI in section 1101C apply to lines constructed prior to May 1st, 2018 as well.
A third point or a fourth point, I'm not sure exactly how far Kim got, is relevant to the commission staff's insertion of the confidentiality provision within the rule. The local governments or our local governments would suggest that we don't believe there is a need for confidentiality. We believe that the pivot to that point from industry with regard to terrorism and other nefarious sorts of things, we have asserted that that's somewhat of a red herring, and we think that there are much larger, more easily visible types of things that are out there for terrorisms to have problems with. So we're not happy with the pivot to confidentiality, and we would rather this commission not insert the confidentiality provision. However, we acknowledge, as Director Lepore said earlier, that if the way to receive geospatial data for old flow lines and new flow lines is necessary because of a confidentiality provision, then our governments will accept that, although we do not believe that there is a need for that. And we would agree to hold that information confidential, that's more important to get the information for new and old flow lines than it is to not get it at all. So that's the third point. The fourth point that we had raised in our testimony, and we had promised to bring alternate language to you, and then no one was allowed to provide alternate language at the last hearing. So we put it in our closing statement. And this was in answer to Commissioner Boygan's concern relevant to our request that local governments be provided discretion on abandonment issues, whether it's abandoning ground or not. And noting that the commissioner did not desire to create authority for local governments one way or another, we have just provided an abandonment language at a new 1105B that provides at least 30 days before implementing an abandonment of an off-location flow line or crude oil transfer line, the operator shall provide notice of the proposed abandonment to the LGD for the applicable jurisdiction. We believe that would then allow those governments that have processes in place to implement those processes having received that notice. So that's the fourth point. And then finally, as Ms. Sanchez noted, the local governments have sort of divided and conquered. We fully support, in particular, the request from the City and County of Broomfield relevant to the reportable safety events and the grade 1 gas leak issue, as well as the proposed integrity management provisions. Anything else? So with that, we would take any questions.
Any questions, commissioners? Okay, then I have a clarification question, and I'm not sure if you can answer this, or maybe someone else may be able to provide this information. When you consider the confidentiality, and assuming it goes forward as it's done now, and there is some incident that occurs that gets traced back to a breach of confidentiality by the local government, where does the liability for that lie?
Well, in our discussions with the director, we've discussed the fact that any local government that receives this information would be using it for emergency planning purposes and planning purposes only, and that it would not be allowed to be provided out, and that we would have to defend the confidentiality of that through a CORA type thing. We've also had discussions with the director that if some CORA requests were made at that point, it's the commission would have a dog in that fight as well. And so I believe it would likely play out that the information maintains the confidentiality. And if it's not maintained as confidential, that's through a court order. And this commission would have been involved in that proceeding, in my opinion.
So perhaps ask you to speculate a bit, because leaks do occur and people's systems do get hacked. So let's assume that your system gets hacked and someone takes that information and uses it for some nefarious purpose. Where does that, now that you've agreed for confidentiality, where does that liability lie?
I do not believe it lies with the commission. I'm not sure whether it lies with the local government if it was through some wanton act that the local government was not involved in.
Okay. Helps some, thank you. Yes, Mr. Jolly.
I have a question about abandonment. You wanted local governments to be notified. And what else once you're notified?
There's no further request to the commission beyond just making sure that those local governments that desire to be notified receive notice. So that's not going to be all local governments. It would be those LGDs that fill out a form or something of that sort.
Okay.
Thank you very much. Any other questions? Any other commissioners? All right.
Thank you, Commissioner.
I believe Northwest, is that right? Northwest Council of Governments is next.
Yes, Mr. Chair.
Thank you.
Great. Are you ready?
Okay, yeah, sorry, go ahead.
No, that's fine.
Got to make a note, sorry.
Thank you, Chair. That's no problem. And good morning, Commissioners. I'm Tori Jarvis with the Northwest Colorado Council of Governments. I'm the Director and Staff Attorney of their Water Quality and Quantity Committee, and appreciate being back before you. A little additional closing time. I definitely won't take 10 minutes, but I want to, as many others have, thank the staff and you all, the commission, for hearing all of us at the last few days of hearing and seeing some changes that reflect our comments is much appreciated. And especially wanted to say thank you and give our support for including an affirmative statement in the statement of basis and purpose that just reflects that Rule 201 would apply to these rules, in that these rules aren't intended to change existing local authority to regulate flow lines, whatever that authority may be outside of anything the commission is looking at. So just wanted to say thank you and give our support that stays in, and we really appreciate that as being a good compromise for not putting it in the rule as we'd originally looked at, but through working with staff, I think that's a really good solution to have that statement in the statement of basis and purpose. And really that is all that I wanted to stress, and that we have been following the other local governments who are certainly much more experts on the issues that you've heard already today, but wanted to add our support for everything that you've heard from the allied local governments and the city and county of Broomfield. And with that, I'm happy to answer any questions.
Commissioners, any questions? Commissioner Boygan?
No, I'll just comment that I appreciate you making the trip from Steamboat, I guess.
Silverthorne. We're based in Silverthorne.
Hey, that's Goldthorne, isn't it?
Yeah.
It's Goldthorne now, right?
Goldthorne, right, yes. How could I get that wrong? Yeah, of course, thank you.
Thank you for continuing the trend of being brief. That's very nice, much appreciated. Weld County? All right, we'll give them the opportunity if they happen to show up. We'll certainly give them the opportunity to come in at another time. So next on our list would be
The Colorado Association of Home Builders is next with 10 minutes, followed by League of Oil and Gas Impacted Coloradans for 20 minutes.
Good morning. My name is Matt Costanet. I'm an attorney with Polsinelli. I'm representing the Colorado Association of Home Builders. I'll keep the trend of being brief going here. All we like to do is say that we appreciate the efforts of the commission and the staff with respect to this rulemaking, and appreciate having had the opportunity to participate in the rulemaking as well. We have nothing to add to our closing statement, which we submitted for the record last week. I have Mr. Ted Leidy here in the gallery as well for any questions, or I'm happy to have answer any questions you might have.
Commissioners, any questions that came as a result of the closing statement?
I'm sorry, I had just one
Yes,
question.
Commissioner Overturf, certainly.
In your closing statement, you, I think, renewed your request that the Form 44s be provided to surface owners upon request. And my question was simply whether you, when you made that recommendation, whether you were thinking upon request to the commission or upon request to the operator. So are you thinking you would go to the commission and say, give me all the Form 44s for this area of land? Or are you saying that you would like the ability to go to an operator directly and ask for Form 44s?
We were thinking that would be in the same way the local government is obtaining that information. So a request to the commission subject to a similar confidentiality agreement.
Okay, and so you support you're okay with the confidentiality provisions that have been agreed to?
Yes, subject to restrictions based on CORA and the other considerations that have been submitted previously in other parties' statements.
Okay, thank you.
Thank you, Commissioner. I think that's it. So
okay, great.
Thank you very much.
Thank you.
Much appreciated. Next is it Logic, I believe, Ms. Bryan?
Yes, Mr. Chair.
Good morning. Actually almost afternoon, and I will be brief. Thank you, and we'll keep.
May we have your name, please? I'm sorry.
Sarah Laughlin for the League of Oil and Gas Impacted Coloradans, as well as Western Colorado Congress and Well Air and Water. I want to first start off by saying that Logic appreciates the significant changes that were provided in the latest rules, and that the rules now require reporting of any accidental fire or explosion, and really appreciate that you included the language around reporting of worker accidents. To conclude, better health and safety protections start with better information and better reporting about incidents that are already occurring. What we had asked for was a reporting of any explosions. Second, that the Form 22 under Rule 602D be amended. And in our closing statement, the list of things that we were requesting in that Form 22 was listed out, including a number of specifics around the event. In addition to that, where we have seen over a dozen explosions since last April, one of the things that Logic is asking for is that while all of these accidents be reported, that they be reported thoroughly so that an annual report could be prepared that helps to determine trends and problems that need to be addressed moving forward. In response to this, Majority Leader Becker over at the Colorado State House has proposed legislation that was also attached with our closing comments that would require a more comprehensive set of information regarding accidents. And so what we would like to see is a combination of support of the legislation and a more thorough examination and evaluation of accident reporting as we move forward. And again, with regard to reporting of any accident, we really appreciate the efforts on the part of the commission. So.
Thank you, ma'am. Any questions for Ms. Laughlin?
Thank you.
Okay, Ms. Bryan? Should we check to see if Weld County is? Nope.
Weld County has no statements.
That's the briefest one yet. Okay, what's next then?
Mr. Chair, next is Oil and Gas Accountability Project for 10 minutes, followed by United Association of Rocky Mountain Pipe Trades for 10 minutes.
Thank you, Commissioners. Paul Zog, again here for Oil and Gas Accountability Project. OGAP was disappointed in the first draft of the rules because it failed to include a comprehensive mapping proposal as proposed by a lot of the local governments here. Then when we saw the revised rules, we were doubly disappointed in the new confidentiality provisions. Number one, restricting the Oil and Gas Commission's flexibility in future situations to holding this information confidential in all circumstances. Number two, suggesting in the statement of basis of purpose that local governments can only receive this with the consent of the operator. Each of these, the information pertaining to flow lines, the general public needs access to generalized information about the locality of these flow lines so that they can protect their safety, make their own life's choices in a way that reflects the risks around them. And when you adopt overbroad confidentiality rules, you create a risk that there will be a trap for the unwary where people are undertaking risks that they're not aware of. Confidentiality should be construed narrowly, not broadly. And the rules and the language in the statement and basis and purpose interpreted broadly, in our opinion. There's a real question whether all of these flow lines are critical infrastructure, as mentioned in the Open Records Act. And in each case, confidentiality must be judged individually and not categorically. For instance, to give you an example, like trade secrets are generally confidential, but when you look at a specific trade secret, you got to say, okay, how was this handled? Was it kept confidential by the person who handled it, and so forth? So to make and enshrine into rules, these rules is inappropriate because it fails to look at individual circumstance. I'm also concerned that the consent provision that's mentioned not in the rule but in the statement and basis of purpose could prevent local governments from doing their emergency planning and planning functions. That there's another statement in the statement and basis of purpose that congratulates local governments for bringing this to the attention of the commission, but then go down a little bit farther and it says, well, operators, if they don't consent, local governments can't have this information. I think that's unnecessary and an overbroad interpretation of confidentiality. We need to help people in the community, like those in Firestone, to protect themselves from risks that are in their neighborhood. Increasingly, what we're seeing with the oil and gas development in Colorado, there's several trends at work here. One is that we're seeing more development in urban areas, and we're seeing more concentrated development. In other words, large pads with multiple wells on them. And one of this reflects an overall increased risk of safety when you're doing these kind of operations within the city of Greeley, within the city of Longmont, within the city and county of Broomfield, and very close to Erie. And, you know, other towns may also, Fort Collins, others, Longmont, that are threatened. We need to really tighten the rein on safety rules and regulations. And we think that broad interpretations of confidentiality are really inappropriate for that here. We also had mentioned, and before I go on, I just say that OGAP also supports the position of the affiliated local governments that they get all of the information, geodatabase information for existing wells, as well as future wells. And we also support them in, support the city and county of Broomfield on their request for notification on grade 1 gas leaks. I also wanted to mention, it was a subject we discussed in our opening statement, that was concerning the abandonment of flow lines. And essentially, the rules do not reflect any concern for that. In fact, the cities and counties that have requested advance notification so they can weigh in on abandonment issues that's not even reflected in the draft or the revised rules. We think that's a mistake. And I know that the rulemaking here is focused very specifically on flow lines, but we see the world in broader terms. And when you look at these trends that are going on, we think that a lot of what you have in your current Rule 900 rules about handling of exploration and production waste is really inappropriate for places like drilling within the city of Greeley, city of Longmont, city and county of Broomfield, and places like that. And going forward into the future, we think this commission is going to have to take those considerations into account. And abandonment of flow lines is something we see as a part of that. We know that there are leaks of these. They're not visible. They're not easy to determine where they're at. And if you just abandon them, you may be leaving gas and liquid contaminants in the ground that creates a safety risk going into the future. I don't have any further comments. Thank you for your hospitality. And if you have any questions, I'd be happy to answer them.
Commissioner Boygan.
Thank you, Mr. Chair. I have a couple of questions. So let me just probe a little bit on both of these issues that you've raised. On confidentiality, are you saying that there should be no requirement of confidentiality, or are you saying that it should be calibrated to particular kinds of flow lines or situations, or how would you, if you were drafting the rule, would you just say it's no confidentiality? I mean, obviously you want mapping and you want it completely public, but what in your view would be an appropriate type of confidentiality restriction, if any?
To not mention confidentiality, but deal with it at the time that you have an open records request, when you have the most information available to you to make a decision that balances confidentiality and safety with the facts at hand, and not making broad generalizations that, oh, everything's confidential.
Okay, that's a fair answer. And on abandonment, I'm not clear on what a local government would do with information that is provided. If local government receives notice from an operator that intends to abandon a flow line, or even has abandoned a flow line, what would be the consequence of that for local government?
Local government has land use powers that they might want to exercise in the event that abandonment is chosen, to consider mitigation or whatever it is that they believe is within their powers.
So for example, would you, I'm sorry, Mr. Chair, I should be asking you each.
Go ahead. I think it's still clarification, so I would say continue.
Okay, so would you, for example, suggest that a local government could require that a flow line be removed rather than abandoned in place?
In my opinion, yes.
And so, just to follow that up, in your view, notice from an operator would really just be the first step, and from that point forward, sort of the commission's role is finished, and then it's up to the local government to decide how to deal with that abandoned flow line?
Well, currently, the way the rule is written is that the local governments don't even get notice until after abandonment is completed. Now, you know, you can say, okay, well, we're not going to preempt local law, but I mean, you essentially preempt local law when they don't even find out about it till after the fact. Okay.
Yeah, I'm just asking what it is what's the process that you're advocating for?
On abandonment, I think that cities should be notified in advance and to take whatever steps that they feel appropriate, if any. They may not feel any.
Okay, thank you, Mr. Chair.
Thank you, Commissioner Boy. And yes, Commissioner Overturf.
Yes, I have a question, I think, for staff to follow up. Was staff's intent that an operator could withhold consent and thereby could be exempt from the requirement to share Form 44s with local governments?
That was not the intent. And I think there's two things we need to, I think, clarify. I may ask Assistant Attorney General Larson to help me, but the primary part, maybe the only part of the Form 44 that we're focused on with confidentiality is the geodatabase information. So all the rest of the Form 44, we have talked about potentially pushing to local governments, having on our website, putting it on the dashboard. So the schematic drawings, layout drawings, all of that information, the location of risers, if that were part of it, there's no intent. The intent is to make that part of our database that is accessible every single day by any member of the public. And I think we've built in that the Form 44s would go to the local governments if it's within their jurisdiction. The confidentiality provisions pertain to the geodatabase information, and there's not, my understanding, my vision is the local governments get that information as long as they will sign that confidentiality agreement so that we all are on the same page about the state's intent to assert certain CORA privileges or exceptions as it relates to that data, and asking the local governments to sort of play by the same rules, that they too will assert those confidentiality provisions or exclusions.
And just to follow up on Director Lepore's comments, CORA specifically requires that the custodian, which is the COGCC, of that geodatabase information is unable to transfer that data to a local government unless it has received permission from the operator to do so.
So, I mean, I think that's true in the context of a CORA request, but not every sharing of information between a state and a local government happens pursuant to CORA. And so I guess I am a little bit concerned that the reference in the statement of basis and purpose, and I appreciate the gentleman bringing this up because I did not put this together until these comments, does create an opportunity for operators to unilaterally withhold that consent and therefore prohibit that sharing. So I would really like to explore this further this afternoon.
Sure. And if you like, I could just read into the record at the moment the portion of the statute, unless you have it before you.
I do, but if you want to read it, you can. Go for it.
I would propose that the language within CORA does provide that information when it says that the custodian shall not transfer any record received from a non-governmental entity without the prior written consent of that entity, unless that information is already publicly available, envisions that prior to the agency providing that information to a local government for planning purposes, they must have received the operator's consent.
Right. And I guess my question that I would like to explore later, I think, is that I completely agree that that is one of the requirements that applies in the context of a local government making a request pursuant to CORA. But not every time we share information happens pursuant to CORA, right? There's information sharing that happens just in the ordinary course of business. I think a lot of our communications with local government designees happen outside of the context of a formal CORA request. So I'd like to, I want to make sure that we're avoiding a situation where operators have an opportunity to withhold consent, thereby effectively eliminating our ability to share this information with local governments, because I think that is an important component of the amended rules.
May I comment also? What the Attorney General is saying is essentially making a category judgment that all of these flow lines are critical infrastructure. And if you look at state law, critical infrastructure depends on something that, if it's destroyed, has debilitating effects. And I don't think that every single flow line we're talking about here is critical infrastructure. And so I don't think permission is required in every single circumstances. And by putting this in the rule, you're prejudging it for all the situations that might occur.
Okay. Any other questions or comments? Thank you very much.
Thank you, Commissioners.
Counselor as well. So I believe the pipe trades are next.
Good morning, Commissioners. My name is Susan Eckert. I am here on behalf of the United Association Rocky Mountain Pipe Trades, District Council number 5. And first of all, we wanted to thank the Commission staff for all their work on the rules and taking our important, although small, piece into consideration and making the changes that we had requested. Our main interest has been in focusing on the certification of the welders and the non-destructive testing. And the most recent version of the rules as proposed by the staff does seem to address both of our concerns. We had looked at the January 26th version, and there still seemed to be a confusion as to section 1102 D2. But now that appears to have been changed and incorporates our recommendation that the certification of workers performing welding on steel lines in pressure service are required to be certified in accordance with the API standards and the ASME code. And since that language has been modified, we do support the language now that appears from the staff, and we hope that the Commission will also adopt that language. And the other section that we were concerned about was 1102 D3, which was the non-destructive testing piece. And the staff in the January 26th version did modify the language to reflect the agreement that the pipe trades have entered into with API and the Colorado Petroleum Council. And I believe since it's all been clarified, we are comfortable with the rules as set forth by the staff. And we believe that these provisions, both the worker certification and the non-destructive testing part, will help ensure the safety of the public and the workers and the environment by helping to hopefully prevent some catastrophic leaks from the numerous welded joints that you find on the flow lines. And we would like both of those sections to be adopted by the Commission. Thank you again for your time and the staff's time.
Thank you, ma'am. Any questions for Ms. Eckert? All right. Thank you again.
Thank you.
Ms. Brine? And just a time check overall, sort of how many are left at this point?
You have 3 left at about 10, 20, 30, 27 minutes left, all told.
So possibly we could complete this before lunch.
So next is API CPC, along with COGA, Noble, and CIG. They had 10 minutes minus 2 minutes for their cross-examination of Broomfield's expert, followed by Anadarko, Crestone Peak, and PDC, who have 10 minutes.
Please.
Mr. Commissioner, I can't promise to be as brief as Weld County, but we'll shoot for something close to that. Again, my name is Jim Martin. I'm from the firm of Beatty Wozniak. I'm here representing API CPC. One quick note for the hearing officer, Noble Midstream doesn't plan to speak this morning.
Okay.
I have only some brief comments on two subjects. But first, I want to reiterate what you heard from Mr. Lepore this morning, that the staff has been tireless and remarkably patient in dealing with this over the course of, I think it's coming up on 6 months, and it would be remiss of us if we didn't thank them and express our appreciation for, most of all, their patience, because they never once even yelled at us, much less threatened fisticuffs. So,
you sure?
Well, not really, not really. So for the two issues I wanted to touch upon, one is section 1102D2. You just heard from the pipe fitters. I believe that the staff has addressed the issue that they and I were going to address, which is to include steel lines and pressure service as part of that section in replacement of crude oil transfer lines. So I won't belabor that point. I want to, again, express our appreciation for the staff's work at addressing that issue and including steel lines and pressure service, so a broader category than just crude oil transfer lines. Mr. Chairman, I also want to offer to make Mr. Lesko available for questions if you're interested. We were not going to offer him in any kind of direct testimony since his declaration's been introduced into evidence, but we can add him if any of the commissioners would like to ask him questions. He would testify to the fact that optical gas imaging or FLIR cameras are not technically feasible or cost effective in detecting leaks from below ground lines. So his testimony is limited to optical gas imaging.
I think if it pleases the commissioners, perhaps would Mr. Lesko be available when we sort of finish up all the presentations if some questions come up at that time?
I'm sure we can make him available at your convenience, Mr. Chairman.
Okay, which it may be that there's some commissioners may want to know now, but they may want to also ask a question later that could come up. All right.
Okay. Other than that, Mr. Chairman, industry generally, and certainly including CPC, support staff's proposal for a stakeholder process. We do believe that there's dramatic evolution occurring within the sector of technologies for trying to detect leaks from various kinds of lines carrying different materials. There's a lot to be learned, and we look forward to participating constructively, collaboratively in that process. With that, Mr. Chairman, I'm going to turn over to my colleague.
Good morning, Mark Matthews here on behalf of the Colorado Oil and Gas Association. I do want to echo what Mr. Martin said about the COGCC staff. They have been very diligent and thorough in wrestling with some very difficult issues and quite patient as well. So we thank you for that. I only have a couple of minutes, so I want to touch on two issues. First deals with the statement and the basis of purpose regarding the definition of produced water transfer systems. It says that such systems typically travel at distances exceeding limits of 1 mile. I think everybody's intent, similar with the crude oil transfer line definition, is to distinguish between off-location flow lines that carry produced water from larger systems that travel from multiple sources over greater distances that have produced water transfer systems, more stringent registration requirements, and more stringent financial assurance requirements, which are appropriate. What COGA wants to suggest, though, is we think burying the definition in the statement of basis and purpose is not the way to handle it. Statements of basis and purpose are useful for commission's interpretation, and they're useful for lawyers in litigation, but nobody really reads them. And This is a very important point for the reason I just outlined. And so I think it's very important that we put in the definition, in the regulations themselves, a definition of produced water transfer systems. We support what the staff has done with regard to distance, typically up to 1 mile or over 1 mile. The word typically is in there because of some ambiguity. We also ask the staff to consider, this was in our prior comments, that because this is a flexible definition, that a diameter definition be added as well. So produced water transfer system is a system that typically travels over 1 mile or has a diameter of greater than 5 inches. I know in conversations with staff, there are some exceptions to the diameter provision, but clearly most produced water transfer systems exceed 5 inches in diameter. The second point, quickly, is we do want to address the issue that has come up repeatedly this morning about the burden of mapping historical flow lines. And if you have any questions regarding this issue about the infeasibility of mapping all historical flow lines, we do have Brian Murray of PDC here who can testify as to specifically why it's difficult. There's already been reference to polylines, historic polylines that don't have metal tracer units that are very difficult to trace. But even in other circumstances regarding topography or surface buildings, it can be difficult to trace historic flow lines. So I submit that the current regulations strike an appropriate balance. They make the strict regulation of mapping for future flow lines, but also say that what is in the operator's possession or in the records of it or its predecessor, that information needs to be divulged. So I think that is the proper balance when dealing with existing flow lines. Thank you. I cede the rest of our time to Ms. Kelsey Waslinski, who will testify on behalf of CIG.
Thank you. Kelsey
Okay.
Waslinski. Oh,
Sorry.
yes.
And this may sort of go a little bit beyond clarification. But one of the things I would ask, and I understand the difficulty with mapping historical flow lines, but when you think about if you're going to go out and do something with that line, which improves the accuracy of your knowledge of where it may lie, would that be an issue for adding that to your geospatial information? So this is an historical line, for example, say that you had a 6-inch line that you chose to run a smart pig through, and that smart pig gives you GPS data.
You know, it could be, and that I think is a proper discussion for the stakeholder group that we've already referenced. What I have been told, and certainly Mr. Murray can testify much more on this, is there is no current magic bullet. You know, there was some references to smart pigging this morning. Most of these lines are not piggable. And so it's not as if on every historic flow line, or even on most, and Mr. Murray can testify to this, you can use a pig with a GIS capability to magically identify the flow line. As to whether, if you had such a technology, that information should be added to the geodatabase, perhaps. And I think under the current language, arguably it is, because it is information available to the operator at that point. That's a matter of interpretation. But I want to submit that part of the reason I suspect that the COGCC left out geospatial database on historical information is because of the burden of including all of that information in one database, hosting that database, and adding to it over time.
And so that may come up for later discussion. Thank you.
Thank you.
Yes, Commissioner Egger.
Is it okay to ask questions now regarding flow line locations?
Sure, you bet.
So I was just wondering if you could speak to a couple things. First of all, the affiliated local governments said a quick Google search comes up with companies that do have technology to find existing flow lines. And I'd like to hear industry's opinion on that. And then also another comment, and I can't remember when it came up, but earlier this morning was, and this will tie into Chairman Benton's comment, if we're requiring ABO inspections and those lines have to be walked, how do we know we're in the right place? Looking for leaks if we don't know where the lines are.
Yeah.
I'll address the first question.
The second question. With regard to the first question, I don't know about the two technologies specifically mentioned by Boulder. That is precisely why a stakeholder group is ideal. For example, during the Broomfield's presentation, when Mr. Hudson, I believe, was testifying, he admitted or stated that his technology was at least somewhat dependent on distance and wind. Again, there's no magic bullet, and that you had to operate in response to Petron's cross-examination, you had to operate a vehicle and have one or two individuals constantly monitoring that line, not constantly monitoring, but operating that system. That is why this is a complex question of a series of nascent technologies that is appropriate for a stakeholder group. So I can't specifically respond to Boulder. I'm just saying, in my opinion, it shouldn't affect what you do with the regulations today. After the stakeholder process, it may at that point. I think that is the best way of handling that. As to your second question, I'm really not qualified to answer that. I don't know if you have time for Mr. Murray to come up and answer it, or if you would rather just he be here during your deliberation.
Commissioner Overturf?
I would rather hear it now. I think it would be inappropriate to have him here during deliberations.
I think that would be appropriate, and since we've asked the question, it does not count against your time.
It's good, because I think we're about out, and CIG is yet to testify.
Yeah.
Brian Murray, production manager for PDC Energy.
Do you want the question answered?
Yeah, I would love that.
Well, I had two, and maybe you can comment on both. And one was that affiliated local governments discussed that you can do a quick Google search and find companies that are available to find these old existing lines. And I'm wondering if that's your experience. And then the second point is, if we don't know where those lines are, but we're requiring AVO inspections that mean someone is walking those lines, how do we know we're even walking where we're supposed to? The inspectors are walking where they're supposed to be walking.
Okay, I'll tackle the first question, and I'll make sure I answer the second question too. They're probably looking at steel lines for locating those lines. I'm not sure. I haven't done the Google searching that local governments have done. The poly lines that don't have the tracer wire are the challenging ones to find. The other point I would like to make is there's been thousands and thousands of wells that have been P&A'd in the state, with the corresponding thousands and thousands of pipelines or flow lines that have been abandoned in place with those risers cut. So those are the lines that are also going to be impossible to go and find to create a comprehensive database. So there's still going to be lines encountered just because they've been abandoned in place historically with no way to go find them. So did I answer your first question? With regards to the second question, I was just corresponding with Ms. Prine. I believe for Ms. Larson, excuse me, I'm sorry. Excuse me, off-location flow lines, the annual pressure testing is what's required for those off-location flow lines, and not having to walk the lines, if I'm interpreting that correctly. So I think the annual pressure testing is what required for off-location flow lines, because some of these lines go thousands of feet through cornfields or through challenging topography. And I think that is what's required to determine the integrity, and not doing an AVO inspection and walking that line.
Yes, you're right. The AVOs are required for above ground, but not below ground. Thank you.
Mr. Chair, can I ask
yes, Commissioner
point of
Williams.
order, and then second, I would like to do some follow-up when Commissioner Agar is through. Is Mr. Murray testifying as a witness, and should he be sworn? I'm not clear on the process here.
I'll ask Mr. Davenport. My thought was it was perhaps more of a comment, but I could be off base there. So
I think there's probably a line if a witness is testifying as to their personal factual knowledge about something as opposed to an opinion is what the rule says, et cetera. So Mr. Murray's testimony in regard to his personal knowledge about things is probably the line, but we are in a somewhat quasi-legislative process here, and don't normally swear people in, and so I don't think it's absolutely required in this case.
Okay.
Okay. Commissioner Agar, I'm not sure if you were...
Go for it.
Okay, so I have a couple of questions. I would like you to speak in general to the issue of mapping. You've already alluded to one difficulty, and that is in connection with P&A wells that have been plugged and abandoned the wells themselves you may not even know about, and flow lines that were attached to those wells and were presumably also abandoned. One can suggest that perhaps the Firestone well fell into that category, although it was reactivated. So there's some gray area there. I'd like you to comment generally about the issues that arise in connection with mapping, because you've heard the local governments testify that they still think mapping is feasible and should be required. What's your response?
Sure, I was going to talk on that, but I've already mentioned a couple of them, and I'll add some. We discussed the old poly lines, the terrain and surface development that was mentioned earlier, some of the challenges with mapping some locations. The 1,000 of wells have been P&A'd, we talked on. And, local government mentioned that they reached an agreement with the operator for smart pigging the lines. I'll speak on behalf of PDC. PDC has over 2,600 wells in Colorado, and not a single pipeline is smart piggable. We don't own a pig, period. So our operation is not conducive to that magic bullet, that extraction signed up for brand new facilities going forward for that agreement that they reached in local government. So that's something that cannot be done for PDC and a lot of other operators, I would stay in the state of Colorado.
Excuse me, could I just ask, is that because the technology doesn't exist, or you just don't want to invest in it?
You heard earlier mentioning on the size of the pipelines. For the diameter that's required. PDC is not a midstream company, it's an upstream company. So the majority of our pipelines are very small diameter. That limits the ability to do that. On top of that, we don't have risers installed or pig launchers and receivers in order to do that. So there is a tremendous cost component, but also just a feasibility just is not there. Local government has said that the current proposed rules are, creating half of a map. And some of the reasons I've outlined to you, I feel like you're still going to have an incomplete map, even if you do include all those off-location historical flow lines for the reasons that we've been discussing.
Can I follow up?
Certainly.
So the language of the proposed rule says that certain information regarding existing flow lines has to be provided to the extent known by operator, or can be ascertained from the operator's records or the records of the previous operator. How would you define, in your mind, what does that mean? What's the standard?
That's a challenging question. I think we've all had debates on that. Excuse me?
The council might be better able to answer that question.
Yeah, I'm sorry, I couldn't hear that.
I just, nothing, never mind.
I take it as whatever records that PDC has through installation of our own pipelines that we were the owner of at the time of installation, or that we acquired through acquisitions, we would provide for that database. But I can tell you that PDC does not have any of our lines GPS or geodatabase right currently, the 1,000 lines that we have right now.
So if you knew, for example, of a person who had been employed by the predecessor company and had some responsibility for installing or monitoring or maintaining flow lines, would you, in your view, would you be obligated to go interview that person, find that person?
I'm not sure if I'm the appropriate person to answer that.
Chairman, we
Yes.
actually have, you asked us to have our witnesses available, those witnesses who presented at the last 2 days of hearings. We have a witness who's done lots of work in this area. If you're interested in hearing from her, she actually has some qualifications that would allow her to answer that question more capably than, sorry.
No offense taken.
Boy, that was.
Let me reframe that. She has some expert qualifications that would allow her to address Mr. Boygan's question.
Commissioner Boygan, would you like to hear from this?
To me, that's one of the key issues of these proposed rules. I don't think it's an enforceable standard, and I don't even know really how to apply it or what it means. So I would love to hear some testimony on that subject.
Mr. Chairman, our witness would be Jeanette Jones from Noble Midstream.
Okay,
If you're interested in hearing from her.
the rest of the commissioners, I mean, we are sort of deviating a bit from clarification, but it does add to the value. So I think if you're all okay with that, we'll hear it. All right.
Okay.
Please proceed.
Good morning, commissioners. My voice is kind of bad this morning. I do apologize. But I do have some experience with due diligence. I work for DCP Midstream for a number of years, and we grew that company through acquisitions. And so getting records was very important. And then just recently, you heard through my testimony that Noble Midstream acquired the Saddle Butte asset here just within the last few weeks. And so due diligence and understanding what records were there were very important to us. Part of the process that we go through when we make an acquisition is ensuring that those records do come through contractual requirements. We put that in those legal agreements, that we want to get all of the construction records, that we can get any contracts, et cetera, as-built drawings. In addition, we go through files. We make sure that all of the file cabinets are emptied, that we get all of those records. So part of the process that an operator could go through is sorting through files. It's a rigorous process. It's time consuming, but it is one of the steps that we go through to understand what kind of records we're getting. Does that help clarify some of the steps that we go through?
Commissioner Boygan?
Want me to,
yes. It's your line of questioning.
Right. Okay. So I appreciate that. That's very rigorous. Noble Midstream is a substantial company which has rigorous procedures. This is more in the nature of a rhetorical question, I suppose, but wouldn't it be true that companies would vary all over the place in how they handle the acquisition of records and even the maintenance of records? Some companies might have records, some companies might not. How can you, is there a standard that you're aware of?
There isn't a standard that I'm aware of. I know that in some cases, I've heard that one of the struggles that a company had was the employees that were being terminated when the acquisition happened, did some nefarious things and basically trashed some records. In order to try to acquire that information, we actually went out and talked to those employees that were still there, not the ones that threw records away, but ones that were still there, tried to get affidavits of what had been built, trying to understand just from their recollection what size pipe it was, any of the construction information that we could gather. So it's across the board. You will get outstanding records from some companies. They will box everything up wonderfully. And then it's up to the operator to just sort through all that data over time. And then other instances, maybe the records never existed when you acquired that system. And you just have to try to piece through what you can. But there will always be gaps in that situation.
That's fair enough. I don't know that I need to pursue specifically with this witness that issue. I think there are a number of questions regarding the standard that's in the proposed rule, which I think her testimony highlighted, but we can discuss it later on, I suppose, in deliberations.
Yeah, I would.
What I'm interested in from the operator standpoint is how do they interpret this language to the extent its information is known by the operator or can be acquired. I guess, well, I don't know. I'm interested in what they think that means.
Perhaps we can get into that. I do have a follow-on question. So in your experience, and you can speculate a bit on this, is that sort of when you've acquired different assets, sort of what percentage of information have you obtained on lines that you've acquired as far as their location? Is it sort of in aggregate through all your acquisitions, or you can be specific, like with this company, we got only 10%, another one, we got 90%, or is it just a range?
It is a range. My experience has been more in DOT regulated lines, and in that situation, you do get a tremendous amount of information. When things are not in that realm, you get much less information. And I think as you start going back into flow lines and smaller producers, you will see less and less of that information available.
So this may be a question for Mr. Murray, since he doesn't do DOT lines. What has been your experience through acquisitions or dispositions for that matter when because PDC has sold some assets? What have you provided the acquiring entity as far as information about your flow lines?
I've not been around for any assets that PDC has divested.
Okay.
When it comes to acquisitions, a lot of it depends upon when the well itself. We're much more interested in the upstream component of the wells, not the larger pipelines that maybe a Noble Midstream or a Salby would be divesting of. So the 2-inch and 3-inch flow lines are not the top of the priority list for the data that we're trying to acquire. The other thing is when you acquire hundreds of wells, the wells that were more recently developed have better information, but the wells that were from perhaps the 80s or so, you get a lot less. So like Jeanette was saying, is there's a range, and typically for upstream E&P, the range would probably be a little bit smaller. For the percentage would be less, I guess, for the type of information we'd be receiving.
And we're mostly focused on non-DOT lines.
That's correct.
So it's again a range. So what I heard was there more information on more recent acquisitions where companies have been perhaps a bit more diligent about, here's where our lines are, 3-inch flow lines or 4-inch flow lines are located. And if you go back 15 years, it's not a lot of information.
Correct.
Available.
It's probably similar to the medical records where if it's digitized, it's a lot easier to transfer that versus if it's just non-digitized, it's a little more challenging.
Okay.
Can I ask one
Yes.
quick follow-up? I'm sorry.
Okay.
Then I'll finish. The proposed rule, even to the extent it applies to pre-existing lines, excludes the necessity of providing the geodata geodata. Is it your sense that that data would just not be available? Is it ascertainable? Is it in the same general category of you might have it, you might not, for existing lines?
Like I mentioned earlier, we don't have any geodatabase for a single pipeline for PDC. We don't GPS our lines. It hasn't been required before, and it's not something that we do. A lot of our lines are 2-inch or 3-inch lines, not larger lines, not DOT regulated.
Thank you.
Mr. Hawkins.
I have a question kind of along the same lines. I know we were looking at existing lines. If we focused mainly on lines that are connected to producing wells, how much of a burden would that be to try to identify a geodatabase for those wells that are producing?
I think that's all the off-location flow lines we're talking about here are attached to active wells.
But you were telling me a while ago, you were saying, well, there's poly lines that you can't find, there's abandoned lines.
And those are attached to active wells as well, that the poly lines are. But you are correct. I did mention that there's a tremendous amount of wells that have been P&A'd throughout the state that are not attached to active wells.
Well, if the commission were to require you to provide a geodatabase for all existing producing wells, how would you go about doing that?
Identify the risers, which to see where the pipelines come in and out of the ground. Look at the diameter of those risers to identify the size of the pipe. Do the best locating that we can, and then if we have to go to greater detail, do that. There will be some negotiation with landowners who will probably have to do some disturbance of the soil to ensure that we are on top of the correct lines, because there will be existing lines that we may start tracing off that have been abandoned in place, which does make it a challenge. We want to ensure 100% that we're looking at the correct lines to make a comprehensive database. And that's where some of the concern is. If it'd be impossibility, in my opinion, to create a fully comprehensive database for a lot of these challenges we say. And my concern would be if we start using that, 811 could be diminished for that reason. The polylines would definitely be a challenge. There has to be a lot of service disturbance on that to identify them. So, we just have to do step by step the best that we could.
And I guess the other kind of midway step would be as you inspect or do work on certain wells that you may be able to identify where those flow lines lie, that information could be provided to the commission kind of as it's acquired. How would you view that kind of a requirement?
I think we're talking about, one thing sometimes we do is replace a flow line when a flow line fails an integrity test, or for whatever reason we do an upgrade. I think that would fall under after the May 1st deadline. So then that would be supplied to the commission if I'm interpreting these correctly.
Okay.
But a lot of the maintenance on the wells or other sites, we would not be ascertaining the GPS for that 1,000-foot flow line or whatever distance it would be, unless you're replacing the entire line,
right,
or laying a new line.
Mr. Chair, may I follow up on that?
Yes, Commissioner Overturf, if you may.
I think just to put a little bit of a finer point on what Commissioner Hawkins was asking is that the way that I read the rules as currently proposed, there's a requirement that if there's an existing line, you have to register whatever information you know by a certain date. And then 101A3 says that if you modify the alignment of a registered off-location flow line, then you have to report that change to the director by filing an updated Form 44. But there may be other ways that you would find additional information about the location of an off-location flow line other than simply modifying the alignment of that flow line. So to Commissioner Hawkins' point, if the commission were to include a requirement that anytime an operator found new information about the location of a flow line, they had to update the appropriate Form 44, would your clients or companies oppose such a requirement?
You think we could perhaps think about it for 10 minutes? And my clients are sitting back there and glaring at me.
For that, I defer to the chair.
Can I ask just a follow-up question for what you mean by finding the location of a flow line? Because I guess if we have a 1,000 or 2,000 or multiple mile long piece of pipe, it's not something that's just going to fall in our lap, I guess, of an actual GPS coordinate of that pipeline.
I'm not talking specifically about GPS coordinates.
Okay.
But rather the way that the rule is written is that your obligation to report is really based on a snapshot in time. And it's the information that you either have or could/should have at that particular moment in time when you file the initial Form 44. And my question is, there may be ways that you come upon additional information about the location of the flow line, additional information that's required in that registration that you didn't know on the date the registration was due, but subsequent you find some additional information. I think the way the rules are currently drafted, there's not a requirement to come back and update your Form 44 unless you are modifying the alignment of the flow line. And so my question is just that, when you come upon additional information about the location of a flow line, is there opposition to updating a Form 44?
Okay, that's fair. I heard location, but so you're talking, just to clarify, Roman numerals 2 through what 8?
Yes,
is that what you're talking about?
Listed in
And none of that
1101
is
little a to big A. There's that lists a bunch of stuff that you need to report in your Form 44.
Yes, and none of that's location, correct? Other than one, which is excluded. That's where I guess I just want to clarify. Because I think you said location, but yeah, pipe material, bedding materials, is that what you're talking about for ascertaining that information later on?
Yeah, I think there also could be instances where you would find out the location of a line. For instance, if a line were piggable and there was a requirement to put a GPS collar on that pig, you might come upon that type of information.
Understood.
I recognize that's not required by the draft rules today. I'm just trying to understand where the industry would come down on that sort of a change.
Commissioner Overturf, so I ventured down this pathway with some trepidation, but I assume that at some point you're going to take a lunch break. We'd be happy to work with the staff in trying to better understand and define your question, but basically for lines within the COGCC's jurisdiction, so leaving aside what you might discover about a PHMSA regulated line or whatever, if the question is whether if a company or an operator discovered new information, they could be required to report it, that's something we could work with the staff on over lunch, and I believe perhaps reach some resolution that would be responsive to your question.
I believe it was also Commissioner Hawkins's question. Yes, thank you.
Which would give you your 10 minutes you asked, since your clients were glaring at you.
That's correct.
I think so I had a question, but I will reserve that for when you come back, because it sort of ties to this, but I know it dives a bit further into beyond clarification. So I'll withhold that until you come back. I think if there's no other questions here for Mr. Murray or Mr. Matthews, we did have CIG.
That's correct, Mr. Chairman.
Speak, and
we have 1 minute left.
Just a time check, Ms. Bryan. How much time does this group
2
have?
minutes, 14 seconds.
Go to town.
Thank you. Thank you, Kelsey Waselinki from Jost Energy Law on behalf of Colorado Interstate Gas. I will be brief. I'll be less than 2 minutes. CIG has been involved in this rulemaking from the start and really has a very simple request, which is to add a clarifying statement in the statement of basis and purpose that through these rules, the commission is not seeking to regulate PHMSA regulated underground natural gas storage facilities and associated flow lines. PHMSA is the governing federal agency for flow lines associated with an underground natural gas storage facility. So while we all may agree that the commission is not seeking to regulate such lines and the underground natural gas storage facilities, it would lead to significant regulatory confusion and uncertainty if we don't include such a statement. So again, CIG is simply asking that a statement be added to the statement of basis and purpose that clarifies that the commission is not seeking to regulate PHMSA regulated underground natural gas storage facilities. Thank you.
Questions, commissioners? So you leave it up to me briefly. Help me understand your concern about why you want to add this statement in there. And I recall there were some things that came up in January about this as well. So if you could sort of help me understand this, because it certainly is not the intent of any of these rules to do that.
Right. Certainly. And I think it's simply a jurisdictional clarification. It was stated in a frequently asked question to the NTO that was issued by the commission that the commission does not seek to regulate such lines and underground natural gas storage facilities, but there is a registration requirement in Rule 313B, and CIG is willing to comply with the registration requirement. They would just like clarification that through registering such lines, the commission is not seeking to regulate these lines.
So what I heard is that there's concern that there may be some confusion
Correct.
with respect to the registration of those facilities, that there may parties other than the commission may be confused about who's regulating that.
Correct. And like I said, we all may agree now that this is not the intent, but I think the failure to have such a statement of record in the rules may 5-10 years from now lead to some jurisdictional confusion.
Okay, thank you. Commissioners, any further questions at this point? All right, so Ms. Bryan, I believe we'd have 2 more. Perhaps it's appropriate that we break for, Commissioner Boygan, sorry.
I'm not sure, again, of the procedure here, but after lunch, when I think industry is going to be returning, I would like them to address the confidentiality issue. And so I didn't get into that in my questioning on mapping, but I think confidentiality is also an area that I'd like to explore with industry after lunch.
Again, that's
whatever the process is.
I think as we get closer and closer to this discussion, we may want to dive into a little bit more detail to understand some of those positions as well. All right. Thank you very much, all of you. So should we recess for lunch for, what time are we supposed to return? 1 p.m.?
You're scheduled for a 1-hour lunch, but you don't need to take a 1-hour lunch.
Why don't we go till
running about
1 o'clock?
15 minutes behind.
I think 1 p.m. We'll be back at 1 p.m. Thank you all.